Boom. How is everyone doing? It's Monday yet again. I thought we just had one of those, and I didn't like it last time. Now they're doing it to us again. So hopefully everyone's doing okay. Hopefully hopefully everyone's rested. I know I'm not, but that's not really my speed. So that's where we are. We've got some stories to talk about here, and we're going to we're going to get through as many of them as we can. I was going to say we're going to get through all of them, and then I realized that there's quite a few, and they are varying degrees of what the hell. So I am going to have a drink. You're not required to do so if you don't want to, of course, but it's been a Monday. I am going to have a canned margarita. I don't know if they're any good because I've never had this brand that I can remember, but we're gonna find out. So, and people, I feel like I'm getting some shade here. What is this? A YouTuber starting on time? My world is going haywire. A LawTube stream that starts on time. The hell you say? I usually start on time. I feel like that's my usual, as opposed to my unusual. Now I know that's not the case for everybody, but we don't need to throw shade. that's it's we all have our different schedules, and you know what? Um, I only managed to be on time by basically planning to be here for 6. That's my secret is I plan to be here for 6 and then I make it for 6:30. So all right. Now, we've got a whole bunch of things to cover, and some of them are news stories, some of them are older stories. I guess we can start out by talking about this one. Did you watch the documentary? Did they try to claim your videos? I'm in that documentary for approximately 4 seconds, and so if they haven't tried to claim my videos because I haven't done a stream using that clip. They might, they might try to claim me if I did. But at the end of the day, people were like, "You should sue," and I'm like, "It's 4 seconds, though." I don't know if I have a claim, but I'm also not going to sue them over 4 seconds. I just, I don't feel that that's where I want to be today. That is to say, I'm also not going to I'm not going to contact them for permission and to to give them permission and sell them a license, because I'm not going to give them my approval. I'm not going to anything like that. I'm not going to sell out on that one. So yeah. Somebody says, yeah, can you even prove damages, Runkle? I wouldn't have to if they made out. So if it wasn't fair dealing or fair use in Canada, I wouldn't have to prove damages. I could just rely on statutory damages. So statutory damages are just provided for in the law. The law presumes that there's damage when they've shared stuff. So yeah. The 5-second rule ain't just for drop food then. It isn't that there's necessarily a 5-second rule or anything like that. That's not really how this goes, but it's just that I don't feel like it would make sense for me to go after them. That's not really what I'd be looking to do. So I'm not going to do that. So somebody was asking, how is the margarita? It's all right. An ideal margarita should have, ice and salt and all of that stuff. I like salt. But yeah. Somebody said, I'm shocked that they didn't feature Rob's bed breaking video. I haven't watched the entire I haven't watched the entire thing, but I get the sense that they were either relying on big channels that they could use to sort of gin up their status, or people who they thought they could essentially make the Depp side look crazy by using. So they didn't want to use the bed breaking video because it features a lawyer / carpenter demolishing Amber's case. So that they didn't want to run with. So yeah. Some people asked me to cover a tragic event, and so I'm gonna do it briefly. And I'll just sort of mention. So this tragic event that people asked me to cover is that apparently one IRS agent shot another IRS agent during training. And I don't know how that happened. That is that's something that's going to be figured out. But they were apparently at a Phoenix gun range, and one of them shot the other. And so it's not entirely clear what's happened. They've been very tight-lipped as to how this went down. It's actually not entirely clear that it was an IRS agent that shot. It was an IRS agent that was killed, but there were multiple different federal agencies there, and so someone else, or it might be a fellow IRS agent. I'm not sure, but yeah. Now I'm just gonna say, I don't know how this happens, because the range I shoot at has been in operation since the 60s, I think. So, you know how many gun-related accidents have happened at the range I shoot at since the 60s? 0. There's never been a firearm injury. There's never been a firearm injury at my range in the entire history of ever. So that says something. That says that the average person is fairly careful at these, at ranges, and doesn't typically, get involved in, there isn't typically accidents. That isn't to say that there aren't any injuries. There are injuries that have happened, like, somebody falls down and, and breaks a leg. That's happened. There have been people who have crashed a car on something. Yeah. Now, one of the things I just kind of wanted to bring up here is this. Because I'm also just going to note that every time I've had a bad safety moment of like somebody scaring me at the range, it's been a police officer. So, yeah. But what is it? The ATF put out this on Twitter /X. And I just want to comment on this one. Blood Rush, I see your comment. I can't talk about it. Just can't talk about that one. Now, so the ATF is putting out here that they're out on the range with special guests from our local U.S. Attorney's Office. And you can see here they are. They've got a bunch of guns loaded. Oh, look, where's this gun pointed? Where is this gun pointed? If you said that one's pointed directly at his balls, you would be correct. We're just going to go ahead and go full Corey on this one. But Yeah, he's got that firearm pointed directly at his crotch. This is not considered safe practice. Just so you know, you should never allow a firearm to point at a thing that you are not comfortable with having it get destroyed. And in this case, it appears that he is surprisingly comfortable with having his crotch get destroyed, and not in the way that people like. Um, how do you know that somebody else didn't leave a cartridge in there? How do you know that, what happens if you bump that thing and it catches and the trigger goes off? What if it's defective? Like, what if it is a defective firearm and it goes off when it's jostled? You just give it a little nudge and it decides to fire. This is not good. This is not good at all. And so, and this was the ATF themselves sharing it. I'm just like, and I'm just wondering, like, why are these firearms pointed downrange? Because there's going to be people walking through here. You don't want people, walking through this. Really, this is not how this gets set up. I'm just going to note, when I do 3-gun, there's a shotgun loading table. And the shotgun loading table is not behind the line like this. It is off to the side so that you can load the gun with it pointed in a safe direction. Here they've got their loading table with everything pointed downrange. I'm just stunned. So, what happened? We don't know yet. We just don't know yet. But they say that he got shot while they were doing a training mission, and I don't like it. I don't like it. There's this thing that happens where you get like police officers who assume because I'm a cop, I automatically have better safety, like nothing will go wrong. And that is not how guns work. Guns do not respect a badge. Guns do not know what a badge is. Guns do not anything. So, I feel like the ATF, that's alcohol, tobacco, and firearms, should not be doing this, and also should not be posting this online as a, as an example to everyone else. Yeah. So I guess that's my commentary on that one. I'm just a little bit horrified. All right. So that's a good warm up, I guess. People wanted to know some of my thoughts on that one. And my thoughts are, don't do it. Yeah, this is an important thing. Becoming a cop doesn't give you plot armor unless you're playing still a cop or not a cop. Yeah. All right. Yeah, and this, if anyone is downrange, we can't even touch the guns, and the safety check has to be done before anyone enters the range. Yep. I can tell you when I go out to the range, if I find the range empty, the first thing I do is I turn on the lights to say, hey, there's somebody downrange, and then I walk downrange to go and look. And I can tell you, the one day I was there, I didn't realize that there was construction going on. There were no signs up or anything like that. But when I got out there, there was a guy downrange with a truck. And I went, oh, right. There's a guy down here with a truck. I am not shooting on this range today, because you don't want to shoot the guy doing the maintenance. That would be bad. So basic safety is, it's a good thing. Susie McPaul, I actually did a commentary on this one. If it's the one I'm thinking of, because there's actually a few of these, but yeah. There's a lot of situations where police officers just don't handle firearms well. All right, let's do a swoop. Swoop. Swoop classic. All right. So somebody's saying, how many meters is my range? I think it goes out to 1,000 meters. So, yep. Patty, I don't think so yet. Now, I did get a notification that there is something at the post office for me. So, yeah. Some people have asked, how am I feeling? My cough is not entirely gone. It is still a little rough, but it's getting better. So I am getting better. I say that and then it kicks me, but it's not nearly as bad. I'm still coughing some stuff up, but I should be fine for today. So the next thing we're going to talk about is we're going to talk a little bit about our favorite crypto bro. And this is a good question. Do you usually get coughs that last for weeks, or is this rare for you? It's not common, but it happens every once in a while. I'll just give a little bit of background here. I've got asthma, and I've also got some sort of surgical complications left over. And both of those things can help contribute to, if I get like a bad cold or a bad flu, sometimes it can move into my lungs and it takes me a while to clear it out. So this is not unknown to me. And for the people who have been like, hey, is this COVID? No, I've gotten tested 3 times, nothing. So it's not that. I should probably go in and see about that'll be something I can do after this stream. But anyway, so I guess I'll swoop again now that we've got this. We'll do everyone's favorite swoop. And I see just a word from the UK. The lung virus is a real thing that's been going around for a while. Yeah, and I was in the UK, so yeah. All right, so hey, Jackson. Yeah, this is my favorite stream on the Citadel. Nice. So let's talk about everybody's favorite crypto bro. I'm gonna possibly cut in on Rob's thing here, but we'll talk about this. So Sam Bankman-Fried, the latest is he got his bail revoked. So he got his bail canceled. He's now in custody. And so he's gone to jail because he just couldn't follow the rules. And the most recent thing he did that got the court to say, you're done, we're tired of your BS, was that he posted he released a diary that was seen as an attempt to intimidate a witness. And I'm going to tell you, if you're intimidating a witness, that is a great way to get your bail revoked, right? There's lots of things that a lawyer can spin for bail. Like, oh, you committed another crime. Okay, well, we can spin that. But you're intimidating witnesses and interfering with the justice system gets people real upset. And as Rob has gone over in past streams, and check out Rob's content, Law and Lumber, for like more thorough coverage on all this. The judge has really basically been asking, like, hey, why don't you revoke this guy's bail a long time ago? Why don't you revoke this guy's bail? So, and Scarlett, and everyone else, if like times are tough financially for lots of people, and if you're in a situation where you are, strapped financially, super chats and so forth should be the last thing on your agenda. This is a luxury at best. Hey, Kurt, how goes? So yeah. All right. So Sam Bankman-Fried wants to see his lawyers outside the jail 5 days a week. 5 days a week. So basically, he wants to just be in jail on weekends, which is not really how revoking your bail works. When you get your bail revoked, you get to stay in jail. That's how getting your bail revoked works. That's what the point is. But he says he needs to be out for, 5 days a week. I think this is a bold ask. I think that this is an incredible ask. But why does he want to do that? Well, he says that it's entirely inadequate, the conditions he's under. He's been given 2 days a week to review the large volume of disclosure, and he's got no dedicated computer or material or ways to share materials with them online. I'm just going to say, you don't normally get internet access in custody. That is not normally a thing. The reason why you don't normally get internet access in custody is that plenty of people in custody can do crime via the internet and might, in fact, be in jail due to doing crime on the internet. Whether that is financial crimes. Oh, hey, Mr. Bankman-Fried. Didn't see you there. Or, say, bad pictures, fraud, sending threats, like somebody who got into a domestic and, was sending threats to their ex. Well, if they have internet access in jail, then they can keep sending threats to their ex. You get like serial killers who want to still send threatening messages to the public. And I see, is this letter on the docket? I couldn't find it. I can only see it reported. So I didn't see it on the docket. Now, federal prosecutors said, hey, listen, we will load all of the documents onto hard drives that you can use at the prison. Like in jail, you can use a computer there, but we're not giving you an internet connected computer. He's also been offered extraordinary accommodations, i.e. he's been offered the luxury wing so that he can, access this. And I'm like, why though? Why? Why? Is it because he's rich? Because you know what happens when one of my clients ends up in jail? When one of my clients ends up in jail, well, if I want to have a meeting with them, then I cart my butt off to the jail, wherever the jail is. And I sit down and meet with them. And if I want to meet with them while, if I want to meet with them and, go over stuff on a computer, then I make a special application to bring a computer with me and go in and do that. And I don't see why he should be any different than any of those. Just because he's got some fame, just because he's got money, I don't put him any higher than like my client accused of drug dealing or robbing a liquor store. You're just charged with a crime and you were unable to follow your bail conditions. So yeah, like you can have pen and paper. We've even given you access to a computer. You can look at things whenever you want, and you can call them and, tell them what you want and all of this, and they can come visit you whenever they want. So if I was the judge and this was the request, my response would be something like, crap, we can't say it for another hour and a half. You just, hey, no, no, like that is just not on. But that's what he wants. He wants this special permission, and I am just astounded at the audacity. Like, sir, you got denied, like, you got your bail revoked because you are a danger to this trial at this point. So why would we let you out for 5 days a week? It just makes no sense. Now, I don't know. I don't have the entirety of this letter, so I am wondering what else he's asking for, because I'm wondering, for instance, did he ask for, like when he says he wants to be out for 5 days a week, does he want to be out and then check himself in at night and sleep at the jail? That's less bad. If he wants to sleep at his own house each night, then it's like, you're not even in jail. You're just basically asking for your bail again that you just got denied. So, yeah, it's ridiculous. All right, now, so that's Sam Bankman-Fried. I think, that might be it. Let me just see if I can find it. If so, then that will be much appreciated, because we will we'll have a look at it. Does that docket seriously start with 666? All right, let's see if I've got this typed in correctly. There we go. Letter motion. Here we go. Let's see if we can bring this up. Thank you kindly, Kurt. That's much appreciated. I couldn't find this when I was checking it out, but that is much appreciated. Let's pull this up. Yep, this looks like the right thing. Here we go. All right. Oops, that's the wrong page that I'm presenting. I want to show you the actual PDF, because that'll be much easier to read. There we go. So, Mark S. Cohen and Christian R. Everdell, on behalf of Mr. Fried. So, dear Judge Kaplan, on behalf of our client, Samuel Bankman-Fried, we write to object to the government's current plan to provide discovery access while Mr. Bankman-Fried is housed in the Metropolitan Detention Center. As set forth below, the plan is entirely inadequate, given the extraordinarily voluminous discovery in this case, and will substantially interfere with Mr. Bankman-Fried's Sixth Amendment right to participate in preparing his defense and his right to receive effective assistance of counsel. Instead, the defense requests that the court order the marshals to produce Mr. Bankman-Fried to the attorney's office proffer rooms on the 5th floor of the 500 Pearl Street Courthouse 5 days a week, so that he can review discovery in the presence of his attorneys and share material with them via Google Docs and email on an internet-enabled laptop. So they want to move him to the U.S. Attorney's office 5 days a week, so he wouldn't be free to wander around. That's better, but yeah. We further request that the court order that defense counsel may bring 2 internet-enabled laptops and 2 mobile Wi-Fi devices, one each for Mr. Bankman-Fried and for defense counsel, into the 500 Pearl Street Courthouse for these meetings, which defense counsel will take back with them at the end of each meeting. I would still tell them, no, you can go and do this at the, you can do this at the jail. As an interim measure, we request that the court order the marshals to produce Mr. Bankman-Fried to 500 Pearl Street for the entire day of his arraignment on Tuesday, August 22nd, and order that defense counsel may bring in 2 internet-enabled laptops and Wi-Fi devices on that day. Because Mr. Bankman-Fried will already be at the courthouse for his 9 a.m. arraignment, we would like to use that opportunity to meet with him in person in the proffer rooms for the remainder of the day. I don't think that one is that unreasonable. But I can tell you what my response would be to this. So, status of discovery access and the government's discovery plans. At the bail hearing on August 11th, 2023, the government represented to the court that it had spoken to the Putnam County Correctional Facility about housing Mr. Bankman-Fried, and that the facility had informed the government that it would permit the defendant to have a laptop that is enabled for internet-based discovery review, which would largely address the concerns raised by the defense about access to discovery. The government further represented to the court that it would take about a week to create a laptop for Mr. Bankman-Fried that would restrict his internet access to the Relativity database and the AWS database. The government also represented that the reason they were proposing Putnam County Correctional Facility was that it would take at least weeks to load the full discovery onto a laptop, and that even then there was no guarantee that the discovery would be readable or searchable in that format. Hence, even at that bail hearing, the government appeared to recognize that internet-based discovery review is the only viable option for Mr. Bankman-Fried to have sufficient access to the discovery and prepare his defense. I don't know that I read that. I think that I would read that as just that they were trying to be cooperative. But yeah. On a call just 3 hours later, on Monday, August 14th, 2023, the government told defense counsel that Putnam County Correctional Facility was no longer an option, if it ever was a viable option to begin with, and that Mr. Bankman-Fried would need to be housed at the MDC. The government further stated that the MDC had not agreed to let Mr. Bankman-Fried use an internet-enabled laptop, although they'd not yet received final word on that issue. The government also stated that it would be a challenge to load the discovery onto a laptop because it is over 4 terabytes of data, and that getting the full discovery to Mr. Bankman-Fried in the MDC was not going to happen anytime soon. How is that a challenge? I'm just going to say that you can get more, like you can get the discovery, like 4 terabytes of data. You can get a 10 terabyte drive. It's not that hard. So just load all of that onto that drive and send it over to them. It won't take that long. Sure, it'll take several hours to copy, but you can just like set that to run overnight. And then in the morning, you're like, here you go, done. Not hard. The government also acknowledged that there was no way to provide Mr. Bankman-Fried access to the AWS database without internet access. Oh, well, that's sad when you get yourself bail denied. The government's interim solution, at least on that call, was to have defense counsel prepare a hard drive containing a selection of important documents that we could provide to Mr. Bankman-Fried in the meantime. Although this is an entirely inadequate solution, the defense has prepared a hard drive which it will send to Mr. Bankman-Fried today, even though Mr. Bankman-Fried does not have a dedicated laptop to review them. Again, your average person charged with a liquor store robbery or a complex fraud or whatever else would not be getting all of these perks. After a brief call on Wednesday, August 16th, in which the government represented that it was still working on getting MDC to agree to provide internet access, the party spoke again yesterday. On that call, the government offered its current proposal, which is the following. And then this is redacted because I'm guessing it is covered by resolution privilege. So blank, blank, and blank. Gotta love redacted documents. This is entirely inadequate, and Mr. Bankman-Fried will not be able to meaningfully participate in his defense, as is his right under the Sixth Amendment. First, the government concedes that given the extraordinary volume of the discovery, internet-enabled discovery review is the only viable way for Mr. Bankman-Fried to get access to the discovery quickly so that he can prepare for trial. Okay, we'll give you more time. I see a question about what is resolution privilege. I'll answer that in a moment. And yet, the government proposes to limit his ability to review the discovery to only twice a week. That is not the understanding that the court expressed at the last bail hearing, which was that Mr. Bankman-Fried would have very liberal access to discovery 9, 10, 11, 12 hours a day. So, and they're citing to the transcript here. So they've already pulled the transcript. So second, it does not appear that Mr. Bankman-Fried will be given a dedicated non-internet enabled computer in the MDC. Hence, he will have extremely limited access to any selected documents we may send him on hard drives because of the staffing shortages we referenced in our prior submission, which would apply to any other inmate at MDC. Third, without access to Google Docs or email, Mr. Bankman-Fried has no effective way to share his work product with Defense Counsel. Have you considered saving it onto a thumb drive and then just giving it to them? I mean, you guys can just go visit him all the time, right? You just get a junior to go visit him and be like, hey, any updates? So redacted is not a meaningful way to confer with his lawyers, putting us in an impossible position and depriving us of the ability to provide effective assistance of counsel. Fourth, just last week, the government produced 750,000 pages of Slack communications, which were supposed to be produced months ago, that Mr. Bankman-Fried will have no hope of reviewing under this schedule. How would he be able to review that much anyway? Meetings with Mr. Bankman-Fried. The impairment of Mr. Bankman-Fried's Sixth Amendment rights is not limited to his inability to review the discovery. Defense counsel went to the MDC twice this week and had to wait 2 to 3 hours each time before Mr. Bankman-Fried was produced. Again, this sounds like what happens when you're in jail. I can tell you, I've had to wait longer than 2 to 3 hours to see a client. I have shown up and I've been told, you can't see them today. There's a riot. And I mean, fair enough. When there's a riot, I get why they can't march me in to see my client. But this is part and parcel of the whole your client is in custody thing, right? It happens. The other thing that's happened is I have actually been trapped in the jail during a riot. So that was fun. That's up at the Fort Saskatchewan Correctional Center, which if you've never been, I don't recommend going, but the Fort Saskatchewan Correctional Center has a big exterior wall around the perimeter. And then inside that, there's like a green space. And then inside of that green space, there is there's like different buildings that the inmates will be using and so forth. So I was outside of the buildings where the inmates were, but they would not open the door to let me out of the wall, like through that wall. So I'm just stuck in this green space, and they're like, yeah, sorry, we're on lockdown. There's a riot going on. I'm like, do you think maybe you could just let me through this door? And they're like, no, we can't. I'm like, there is no one around. Nobody is going to rush it. Like, you could just let me through this door and lock it right behind me. And they're like, nope, have a seat. We'll get with you when we can. I'm like, okay. So you just sit and you wait. And I was there for about 3-4 hours. It just happens. Somebody asked, how do I, who pays me during this time? I can tell you who pays me during this time. Nobody pays me during this time. You just that's just wasted time where you just are stuck there. And that's it, right? So, what do you do if you've got to wait 2 to 3 hours each time before they are able to produce the guy? Well, you bring some work you can work on, right? That's all you do. This is a good comment. As long as the food is good at the prison, I'll consider vacationing there. The food is never good at the prison there. 0%. It is 0%. Complaining about a 4-hour vacay. It's not a vacation when you're sitting and you don't even have a chair. And you're wondering if a riot is going to spill over and then you might get overtaken by angry prisoners. So that's less of a vacation and more of a concern. All right. while we would probably be able to work through these delays under normal circumstances, we no longer have the luxury of time given the extraordinarily voluminous discovery and the proximity of trial. It is therefore critical that we be able to meet with Mr. Bankman-Fried outside of the MDC in the 500 Pearl Street proffer rooms to be able to prepare his defense. Or, I don't know, they could just make an order that you get special priority so that you don't get 2 to 3 hours. Or you just do what all of the criminal lawyers are doing, which is just that you go and you wait and then you go see him. For these reasons, the defense requests that the court order the marshals to produce Mr. Bankman-Fried to the U.S. Attorney's Office proffer rooms on the 5th floor of the 500 Pearl Street Courthouse 5 days a week so that he can review discovery in the presence of his attorneys and share materials with them via Google Docs and email on an internet-enabled laptop. Are they actually going to be meeting with him 5 days a week? That's impressive. That's impressive. We further request that the court order the defense counsel may bring 2 internet-enabled laptops and 2 mobile Wi-Fi devices, one each for Mr. Bankman-Fried and for defense counsel, into the 500 Pearl Street Courthouse for these meetings, which defense counsel will take back with them at the end of each meeting. And as an interim measure, they want that one day on August 22nd, which is tomorrow. So I guess we're going to find out tomorrow what happens, and then that will probably get covered on Friday Night Frenzy. What they're asking for is very very unusual, at least in my experience. So I just I know what my response would be. My response would be no. And in fact, emphatically no. I also like the suggestion I see in chat of just take those millions of pages of Slack communications and print them out and deliver them in boxes into his cell. Here you go. Here's you'll have to give him an entire cell wing for that, because it'll just be all right, you've got 400 boxes of documents, go nuts. But the thing is before the internet, that's what we did all the time. So, yeah. Oh, and I'm seeing this. Bankman-Fried got internet via his lawyer's laptop in the courthouse 9:30 to 3:30 on August 22nd. 1 laptop, 1 Wi-Fi device. All other relief was denied. Oh, nice. So he gets 1 round of internet connection. The rest of it, the judge is like, I am out of patience for you, and y'all can go to hell. So I just kind of feel like this is one of those situations where if you don't want to have trouble with this, there's an easy solution, which was don't try to intimidate the witnesses. It's not even that hard to not intimidate the witnesses. I'm not intimidating witnesses right now. Super easy. I bet most of you are currently not intimidating witnesses. Right? At least I hope. All right. Let's go through some super chats here, and then I will swoop and so forth. All right. So Rhineman YYC, thank you for 10 gifted memberships. Cat Vetter, thank you for 10 gifted memberships. Stephanie 1208, thank you for 5 gifted memberships. Angie Torres, thank you for 10 gifted memberships. Iowa with the Backyard Critter Cam, thank you for 5 gifted memberships. Pants, thank you for 5 gifted memberships. I'm curious about the Backyard Critter Cam because I've thought about trying to set one of those up for the doggos there. Ray E is saying, it always makes me smile that there's actually Canadian government guidance on how hard the math problem has to be in order to win $1 million. What he's referring to is the rules in Canada basically says that you can't give things away by pure chance. Even if there's no money involved, you can't give things away by pure chance. So what that means is that you have to have skill testing questions. And these skill testing questions are required to be a test of actual skill, but they don't necessarily have to be hard. So there is case law that establishes to say, like, listen, this is how complex it has to be. So you can't put 1 + 1 is 2. That's too simple. But if it's got, I think that they said 3 steps to it. So like 1 + 1 times 7. And then all of that is divided by, 2. Like, that's fine. So, yeah. Is it true that AR-15s can't go to the range, but people who are grandfathered with full autos can? How is that logical? Currently, in theory, the law allows for taking a full auto to the range. In practice, they never give those permits. They just don't. So, yeah, no, the full autos are not going to the range. Kayla M., thank you for the YouTube membership. Much appreciated. Torin 3, you are feeling better. A bit, yep. The 2-camera split screen is popular enough that I've got to build a computer so I don't have to use 3 USB extension cables to reach the seller computer. 1,200 watch hours to YouTube monetization. Guys, check out Torin 3's channel. He does Tatakai, I think is the pronunciation, braiding. Let me show you the braid. I got it right behind me. So you can see this. It is a cool process, so go check that out. And I find it super relaxing. So when I have a project I've got to do to work, and I need something to listen to that's kind of pleasant, relaxing, and so forth, I go check that out because, yeah. Oh, and we've got Nicholas Starro in the chat here. Hello, Nicholas. How are you doing? I know Judge Kaplan, this is not going to happen. Apparently, it did not happen. Judge Kaplan has been signaling throughout this process how pissed off and tired he is of Sam Bankman-Fried, and basically asking the prosecution, like, why have you not dropped the hammer yet? And basically, with Sam Bankman-Fried, he was like, it's hammer time. Put on his puffy pants and, hammer time. So, yeah, I'm glad that he's not getting that. Forgot it was Monday today, on vacation in BC. Lots of smoke. I hope you have a good vacation all the same. Stay away from the evacuation areas because, yeah. Koru saying, I finally picked up some basic leather tools. Now I need some leather. That is cool. Keep me posted, Koru. I want to know how that goes. Harriet Cadle, thank you very much for the $20 super chat there. Much appreciated. Pants, didn't Paris Hilton get released because she was scared of prison? Affluenza, I think they're calling it. I mean, there is a certain aspect that celebrities are at more risk in jail. Some gang member might want to achieve notoriety because, by stabbing up this celebrity, person. But you can protect them in all sorts of other ways, and I feel like they should. Some other people have asked if I'm okay with the fires. I'm well away from the fires, but some of my family is close to the evacuation zone, so I hope that they don't have any evacuation issues. Fingers crossed. Yeah. Bankman-Fried got internet via his lawyer's laptop in the courthouse 9 to 3:30 on August 22nd. One laptop, one Wi-Fi device. All other relief was denied. Lol. Lol indeed. And screw that guy. You intimidate me, or is that arousal? Okay. Dial it back there, Kurt. When lol, Hey, SBF, this is what happens when you F around long enough to find out. Yeah, this time it's SBFAFO is where we're at on this one. All right, so let's have a look here, or let's do another swoop. All right, so our next story is all about facial recognition. Facial recognition is it's getting used more and more. They're using it for all sorts of things, and all sorts of things. And quite frankly, some of them are a little terrifying. One of the things that is terrifying is its use in policing. And that's what brings us to our next case here, which is the United States, Portia Woodruff against the city of Detroit, LaShantia Oliver, and that's the city of Detroit police detective individually and in his official capacities. Is LaShantia I did not think that would be a male name, but I guess that might be an error. So, this is a case about facial recognition and some real it going real sideways. Let's have a look at this one because it's a piss off, but it also just illustrates how you are potentially at risk of being arrested when you haven't done anything. So, now comes plaintiff. Hey, wow, now comes instead of comes now. Still sounds like a Victorian porno. Maybe like slightly later. What era was after Victorian? Yeah. Portia Woodruff, through her attorneys at the law offices of Ivan L. Land, PC, and she states the following for her complaint. Introduction. Facial recognition technology has long been known for its inherent flaws and unreliability, particularly when attempting to identify Black individuals such as Portia Woodruff. Now, that is true. Facial recognition largely struggles at the moment with Black faces, and there's two reasons for that. One of the reasons is that they just don't have enough Black faces, and I mean that in the sense of like actual Black people, not like Trudeau, in their database. Most of these databases have been trained on largely white faces. But the other problem is that just because of the actual coloring, like the actual difference in terms of contrast and so forth, the systems just have a much harder time picking out those details that they rely on. So this is a known issue. It should be understood that facial recognition alone cannot serve as probable cause for arrests, as a computer's identification is prone to errors that humans might also make. This is true. Humans are god awful at making, identifications. They think they're good, but they're god awful at it. And Rafui is noting, I've heard many cases of this also happening with gaming software, most specifically Xbox. The other place where it's happened has been like online testing systems where white people sit down and it's like, okay, we've got like a camera to monitor your face and to make sure you're not cheating. But Black people have been, noting that they go in and they sit down and the thing says, not enough light, turn up the light. And so they have the choice of either the system locks them out or they have to like light up their room like it's the inside of a nuclear reactor. And not just any nuclear reactor, we're talking like Chernobyl, in order that it'll actually pick up that they have a face. Computer systems, for whatever reason, are bad at this. And so this is becoming a problem. It's becoming a situation where One person said that they found a solution to it, which was literally to put on white face paint, and then they were allowed to take their test. So, yeah, it is what it is. Portia Woodruff, a 32-year-old resident of Detroit who lived with her two children, ages 12 and 6, and her fiance. Notably, at the time of arrest for robbery and carjacking, she was 8 months pregnant, and they include a picture of her, just so you can know what 8 months pregnant looks like. She's not like subtly pregnant. She's like substantially pregnant. That is like, yeah, you're not going to mistake that for anything. It's not like, oh, hey, you just had a big dinner. That's clearly pregnant. Now, you still don't ask, hey, is this person, pregnant or not? You just like, hey, yeah. And half Irish, cool. I haven't actually seen MLS's coverage, but he does good work. On February 16th, 2023 at 7:50 a.m., Ms. Woodruff was preparing her children for school when she was confronted by 6 Detroit police officers at her doorstep. They presented her with an arrest warrant for robbery and carjacking, leaving her baffled and assuming it was a joke, given her visibly pregnant state. However, the officers made it clear they were serious and proceeded to arrest her. When there's an arrest warrant out for you, they don't necessarily do it at a convenient time or place. And in this case, she's trying to get her kids to school when they're tagging her here. That's obnoxious, because now, and sometimes there is a real risk where people, people end up with their kids going into custody or into like care because they decide to arrest them while they've got their kids, and it's like, what happens with my kids? So yeah. Miss Woodruff later discovered that she was implicated as a suspect through a photo lineup shown to the victim of the robbery and carjacking following an unreliable facial recognition match. So here's what they did basically. They took the person who was the victim of the carjacking and the robbery, and first they ran through they ran facial recognition. I'm guessing that they had like a video or something, and they ran that photo recognition, and it came up with sort of a possible hit. And then they took that photo that was the possible hit, and they showed it to the victim, and they said, "Is this, your person?" And they picked it out. They actually did a slightly better lineup than that, as we'll see, but I'm going to criticize their lineup as well. So this case highlights the significant flaws associated with using facial recognition technology to identify criminal suspects. I'm not trying to yell, I'm just talking. I got these things in my ears that make it hard to hear. I can tone it down. Despite its potential, law enforcement's reliance on facial recognition has led to wrongful arrests, causing humiliation, embarrassment, and physical injury, as evident in this particular incident. Keep in mind, it could go beyond physical injury. It could, in fact, go to, like, somebody could die over this, right? The police show up with an arrest warrant to, for you. They kick down your door and you happen to be sitting there cleaning a gun at the time. They will drill you. Or, you just hear shouting and you come down the stairs with a shotgun and the cops shoot you because you don't necessarily recognize that. All right. So the Detroit Police Department has faced similar situations in the past with individuals like Robert Williams and Michael Oliver, 2 highly publicized cases. These 2 individuals were also falsely accused by the Detroit police due to the reliance on facial recognition. Detroit seems like it needs to knock off the facial recognition. The need for reform and more accurate investigative methods by the Detroit police has become evident as we delve into the troubling implications of facial recognition technology in this case. All right, so jurisdiction and venue, basically, we're going to skip over. So, facts. On January 29th, 2023, Lawrence Walker, hereinafter victim, this is the guy who got robbed, reported to the Detroit Police Department that he'd been robbed at gunpoint for his personal property and his vehicle. On January 30th, 2023, Detective Oliver from the Commercial Auto Theft Unit of the Detroit Police Department was assigned the case. On January 31st, Detective Oliver contacted the victim and was informed that victim's cell phone that was stolen during the robbery had been returned to the BP gas station. Detective Oliver learned that the cell phone was returned to the BP gas station by a female. Detective Oliver went to the BP gas station to view the video footage of the individual female that had returned the cell phone. Now, keep in mind, this is not the robbery. This is the person returning the cell phone. So, even if they went and grabbed this person, I would say that this is not a great case for the prosecution, because all you've got is that they returned a cell phone. Why would the robber who took the cell phone return it to the gas station? Why would you do that? I mean, if I just finished robbing somebody and carjacking them and I ended up with their cell phone, I can tell you I would just yeet that out of a window. And then some other kind Samaritan might find the phone that was just yeeted out of a window and return it to the nearest business, like a gas station, if they found it. That seems like a much more coherent explanation for this. That seems like it makes more sense than this being the robber. Like, the robber just, why would you go back to, it makes no sense. But he submitted an avert request to members of the Detroit Police Department to extract the video. Once the video was extracted, they submitted a facial recognition request on the female that returned the cell phone to the BP gas station, which returned identification for the plaintiff, Portia Woodruff. So, several days later, on February 2nd, 2023, Detective Oliver had an interview with the victim, who stated that he met a female named Trinidad at the Hoover Market on January 29th, 2023. I'm going to say Trinidad is probably a street name. You got people who use street names because they're like homeless or criminals or whatever. And so you get clients who go by Spider or, all sorts of things. Trinidad sounds to me like a street name. Victim stated that he and the female had engaged in sexual intercourse at a liquor store, a fact that victim had not disclosed during the initial interview with police. Why are they mentioning this? Well, it's because this is telling us that this case is getting even weaker, because you've got this guy who has a changing story. Victim then stated that he and the female went to the same BP gas station earlier that day, and the female interacted with several individuals at the gas station. Victim stated that after he and the female left the BP gas station, they traveled to Bessemer and Gratiot, where victim was robbed and carjacked by a black male. Victim stated that the black male suspect was one of the individuals that the female interacted with at the BP gas station earlier. So, they think that, that they're in cahoots somehow. Detective Oliver returned to the BP gas station a second time to view additional footage, since victim claimed that he and the female stopped there before he was robbed and carjacked. Detective Oliver stated in detail in her report what she observed in the video footage, and there was no mention of the female suspect being pregnant. No mention. So you would think that if you're watching this person on CCTV footage, that you would understand, like, you'd recognize them as pregnant. That, we saw the pictures. She was real pregnant. Really, really pregnant. You're not going to hide that, like, you know, yeah. On February 2nd, 2023, a black male was arrested driving victim's vehicle. Victim was brought to the Detroit Detention Center to view a live lineup of the male suspect that was driving victim's vehicle. So a live lineup means that he's actually there in person. Victim positively identified the male suspect that was driving his vehicle as the individual that robbed and carjacked him at gunpoint. Detective Oliver interviewed the male suspect, who admitted that he knew a female named Trinidad, but Detective Oliver failed to show the suspect a photo of plaintiff, i.e., they've got this guy talking, right? He's confessing, but they don't show him a picture to be like, is this Trinidad? And that might have been a key thing, right? That might have been important. Victim was shown a 6-pack lineup, and I'll talk about what a 6-pack lineup is. I mean, you can sort of see the layout here. And victim allegedly identified plaintiff, Portia Woodruff, as the female who was present when the robbery and carjacking occurred. Now, I just want you to look at this lineup, because we'll talk a little bit about lineup design here. Yes, Trinidad is a lady. So here is the lineup. Now, you see you're getting 6 images. Now, the idea of this is that you... this is not the best way of doing a lineup. The best way of doing a lineup is that instead of presenting all of these pictures at once, you show them one picture at a time in a sequential book. And at each time you say yes or no to each picture. And if it's a no, you flip on to the next picture and it's gone. Now, you might be wondering, where do they get these pictures? Well, typically they get these pictures from mugshot photos. And somebody is trolling, but it is actually a comment that we can make some use of, even though it's trolling. Shameful lack of diversity in that lineup. You don't want diversity in a lineup. In a lineup, what you want is that all of the details that somebody has given you for, to identify them, you want those to be the same details that they are shown or that you use to pick out pictures. So if they say that they were robbed by a white male, every picture that you show them should be a white male, right? Because otherwise, what are you doing? You can't actually go and you don't want it to be a situation where you show like 5 white people and 1 black woman, because in that case they will always pick out the black woman. But here's sort of their lineup. It's not the worst lineup I've ever seen. It's not terrible, but at the same time it is not fantastic. Now, each of these pictures will have been taken from a booking photo. So each of these will be somebody who is each of these will be somebody who's been arrested. So, but the whole thing of like 6-pack lineups is really common, but it's not the best way to do it. It's not how this should be done. So, yeah. All right. The photo used in the lineup of plaintiff was from an arrest in Canton, Michigan from 2015. Despite having access to plaintiff's current driver's license, it was not used in the photo lineup. And I can tell you why it's not. Oh my God, I can tell you why it's not. They should not use it in the lineup. Because you see this picture. It's her zoomed in. You can't see her shoulders. All of these you can see sort of shoulders. It's like the face is a little further out. Smiling. How many of these people are smiling? None of them. And the reason why they're not smiling is that they were just arrested, right? These are booking photos. And the blue background, you see each of these has the same sort of background, different lighting, but the same sort of background. This one's got bright green background. So if you actually put in the driver's license photo and threw that in there, I think that would have actually been a really terrible lineup as well. That would have been a really bad lineup. But the problem is that this was used from an arrest in 2015, and it's 2023. So this is a very old photo. This lawyer is wrong about saying like, oh, they could have used the driver's license photo. That is a ridiculous thing to suggest. It is improper. They should never use that driver's license photo. F them. However, they also shouldn't have used an 8-year-old picture. What they should have done is not this. I mean, it might be that you just can't do a proper photo lineup here, unless you've got sufficient grounds to actually arrest the person and get a thing, or unless you're going to get pictures that actually match to the same kind of style and so forth. I see we can't smile on our driver's license pics in Ontario. Nicholas was saying the same thing about Sweden. Apparently you can in Michigan, or maybe just nobody cared. But yeah, I mean, she's smiling. It would have been the only smiling picture. It would have been the only well-lit picture. It would have been the only one with that green background. It would have been so unique. So now I should note, this isn't a criminal defense attorney. This is a civil case. So the civil lawyer doesn't do criminal defense work, I don't think. And that's why they're making this mistake. Or they are making this mistake because they hope the court's going to make this mistake, and they're just hoping to lead the court or a jury into error here. That is also possible. So Detective Oliver requested a warrant for plaintiff's arrest following unreliable facial recognition hit and from victim allegedly identifying plaintiff in a lineup from a photo that was 8 years old. And really, nobody mentioned pregnant, right? You would think that the victim who had sex with this woman would indicate 8 months pregnant, right? You'd think that that's a thing that would come up when you're trying to identify this person. By the way, they were 8 months. And if they didn't say, by the way, they were 8 months pregnant, you can kind of assume that they weren't, right? It's the same as if you've got like a giant, massive growth on your head, and somebody doesn't mention it, then it's probably not you. And somebody's saying, first-time offender, they can't do a photo lineup. It's tougher to do it well. There's ways that they can do it. All right. So on Thursday, February 16th, 2023 at 7:50 a.m., plaintiff was helping her 2 children get ready for school when she heard a loud knock at the door. Plaintiff approached her front door and observed 6 Detroit police officers. Wow, they were not messing around. One of the officers asked plaintiff when she answered the door if she was Portia Woodruff, and plaintiff responded, yes. If an officer has a question for you, then the answer is, I don't have to answer your questions, officer, unless they do. The officer informed plaintiff that I have a warrant for your arrest, step outside. Plaintiff assumed the officer was joking. Now, I mean, it's never a good idea to assume that the officer is joking, because why would they send 6 cops to your door to tell you a joke? I mean, I know police officers can sometimes be a little overly cautious and a little overly worried. Oh, hey, we've got an EDB raid. Hey, how's everyone doing? So I know people can be a little worried about, like, police officers can be a little cautious, but they're not going to send 6 officers to your door for the purpose of telling you a joke. That is not a service that they offer. So plaintiff asked the officer what the warrant was for. The officer refused to tell plaintiff what the warrant was for. Where I am in Canada, they are required to tell you what the warrant is for. They're required to tell you why you're being arrested. Another officer finally informed plaintiff that she had a warrant for arrest for robbery and carjacking. Plaintiff asked the officer, "Are you kidding? Carjacking? Do you see that I'm 8 months pregnant?" And I'm just going to note, like, if you have a giant, like, you've got a giant pregnancy belly, it's going to be tough to, like, get into a car in a hurry. So, on that date, plaintiff was approximately 8 months pregnant. Plaintiff realized that the officers were serious, so she was forced to tell her 2 children, who stood there crying, to go upstairs and wake plaintiff's fiance to tell him that mommy is going to jail. That is, that's a rough conversation to have with your kids. That's not a topic anyone wants to have with their children. Yeah. Plaintiff's fiance rushed downstairs to figure out what was taking place. No kidding. Once downstairs, plaintiff's fiance learned the plaintiff was being arrested for robbery and carjacking. Plaintiff and plaintiff's fiance urged the officers to check the warrant to confirm the female who committed the robbery and carjacking was pregnant, but the officers refused to do so. Now, I'm just going to say, the officers at the door probably didn't have the information, because the officers at the door, like, the warrant isn't going to say, please arrest this woman who is pregnant, right? They're not going to say that. They'll just say, you are here to arrest this person. And they probably aren't going to call the detective and say, hey, she says she's pregnant. Does that jive? They have an arrest warrant. They're just going to execute the arrest warrant. Plaintiff also called her mother before being arrested and reluctantly informed her mother that the police were at her home arresting her for robbery and carjacking. Plaintiff's mother attempted to explain to the officers over the cell phone that it is not possible, stating, she's 8 months pregnant. There's no way she can carjack anyone pregnant. I mean, makes sense. Despite plaintiff and her family's pleas, plaintiff was taken to the police vehicle, searched, handcuffed, and arrested for her family and neighbors to witness. Plaintiff's fiance also recorded this arrest on his cell phone. Ooh, we might get that. We might get to see that. Ooh, hey Rob, how you doing? So, yeah, this is a good one. Resurfacing from hiding to say hi. What did I miss besides your snark/spice? We are reviewing the arrest of a woman who was wrongly ID'd, in part on facial recognition and in part on a bad lineup. They think that she was carjacking when she was 8 months pregnant, which, obviously not. Plaintiff was taken to the Detroit Detention Center, where she arrived around 8:20 a.m., and she was processed and booked. While being booked, plaintiff disclosed that she was diagnosed with gestational diabetes for a pregnancy. Really common. Women get temporary diabetes while they're pregnant. If you weren't aware, it can happen. In fact, it happens a lot. While at the Detroit Detention Center, plaintiff was not able to consume the foods or beverages offered because of her diagnosis. I don't know what strange food this is, and I can tell you a lot of the food that they offer in detention centers is really crappy. And if I'm a police officer and I'm dealing with an 8-month pregnant woman, I'm being really careful about making sure she gets everything she needs. And surely that's what these officers did. Not do. Plaintiff was able to talk to a court-appointed attorney at around 1:30 p.m. via video. Plaintiff informed the court-appointed attorney that she was 8 months pregnant. And I can tell you what the court-appointed attorney's reaction to that one was probably something along the lines of, are you kidding me? Seriously? Okay, let's see if we can undo this. And yeah, in most states, the most of the food is carbs, like sandwiches and Kool-Aids. Where I am, it would be a crappy sandwich. And by a crappy sandwich, I mean 2 slices of bread, maybe butter, maybe. No guarantees. The butter is, you got about a 50-50 shot on that. A slice of bologna, bologna in there. And that's it. Like, that's the sandwich. It's just bread, bologna, butter, maybe. And then you'll have juice to add to that. And the juice is typically the highest sugar concoction that you can ever possibly get. So like super, super sweet. No fruit has actually been near this juice, but it'll just be that. The court-appointed attorney informed plaintiff that she would request a personal bond at arraignment since plaintiff was pregnant, i.e., we don't want you to have to put up money for this. So, yeah. All right. So, yeah, they just don't want her to have to put up like, $20,000 or whatever. Just like, hey, let her out. After plaintiff was interviewed by the court-appointed attorney, plaintiff was taken back to the holding cell. Approximately 30 minutes later, plaintiff was taken back out of the holding cell and taken to a room to talk to Detective Oliver and an unknown detective, i.e., she's now being taken to have like her police interview. So this is the, and this is the point where she's waddling in to this detective who should at this point be like, wait a minute, I saw this on video. You are not, you're not pregnant, or you're pregnant. The person I'm looking for is not 8 months pregnant. Let's call this a day. That's how that should go. It should just be like she walks in and the person's like, oh, somebody screwed up. All right. Do you know someone named Daniel White? No. Do you frequently visit a BP gas station on 94th and Van Dyke? No. A person made a report that he was carjacked by a black male and that you were with the black male. Plaintiff says, that's impossible. Detective Oliver says, how many tattoos do you have? She says, 5. Can I see the ones on your right arm and wrist? Yes, and she shows the tattoos. Are those the only ones you have on your arm? Yes. What kind of cell phone do you have and who's your carrier? An iPhone and Xfinity Mobile. How did my name come up? You were identified by the victim in a photo lineup as the individual that was with the male that robbed him and carjacked him. Plaintiff, did the victim say the female was 8 months pregnant? Detective Oliver, no. Yeah. This is looking really bad. Despite knowing the plaintiff was not involved in the robbery or carjacking, Detective Oliver directed plaintiff back to the holding cell. Plaintiff was arraigned approximately 2 hours later on the charges of robbery and carjacking. Plaintiff received a $100,000 personal bond and was told not to leave the state by the magistrate. Why would the prosecution not just be like, or we'll just drop this? Plaintiff was released from the Detroit Detention Center at approximately 7 p.m. So she spent the whole day there. I gotta say, this is like one of the very few times that I've seen somebody win a police interrogation, because she actually got the detective to say something. Did the victim say the female was 8 months pregnant? No. She actually got the officer to say something that was against the officer's interest. She actually managed to cross-examine the officer out of something, because this is great for her civil case. This is fantastic for her civil case. So she gets to get a point for winning this interview. All right. While at the Detroit Detention Center, plaintiff stood and / sat on a concrete bench for approximately 11 hours before being released, since there were no beds or chairs available. I can say that it's very common that the detention center setups don't actually have like a proper bed. What they'll have is like this concrete bench that works as both a bench and a bed. And you just kind of, if you want to sleep, you lay down on the concrete to sleep. And I can say that's really not comfortable. That's really not, people don't like that. I've slept on concrete. It sucks. I don't recommend it. Once released, plaintiff was taken to St. John's Hospital by her fiancé because she was suffering from stomach tightness and pain, whole body pains, headaches, and body weakness. While at the hospital, plaintiff was taken to an examination room for observation. Plaintiff was diagnosed with a low heart rate because of dehydration and given 2 bags of fluid intravenously. So, they made her need to go to the hospital, like, for dehydration. And if I get a little dehydrated, oh well, big deal. I'm not pregnant. I'm not gonna be pregnant, but a 8 months pregnant woman getting a low heart rate and dehydration is a big deal. And I'm just gonna note they gave her 2 bags. 2. That's a lot of fluid. That's a lot of dehydration. I'm impressed that they're giving her 2 bags of fluid. Yeah. Plaintiff was discharged from the hospital and instructed to take medication, maintain a healthy diet, stay hydrated, and ensure ample rest to safeguard the well-being of her unborn child, who was impacted by the situation. Oh, sorry, I skipped the line. Plaintiff also learned that she was having contractions due to stress from the day's events. Like, stress can throw you into premature birth. So I'm guessing they gave her medication to suppress that, and we're like, let's finish out this pregnancy so you don't have, a premature child. Yeah. Hospital staff also told plaintiff that her doctor would be in contact with her in the next 24 hours. The following day, plaintiff contacted Detective Oliver to have her cell phone returned. Although Detective Oliver knew plaintiff was not involved in the robbery or carjacking, Detective Oliver refused to release plaintiff's cell phone to plaintiff. Why? Don't know. Detective Oliver informed plaintiff that a warrant was obtained to get a call detail from Xfinity Mobile to determine if plaintiff was in the area when the robbery and carjacking occurred. Why? You already at this point had to know it's not her, right? You had to know, because your video does not show 8 months pregnant. Your witness does not say 8 months pregnant. Your other witness does not say 8 months pregnant. Nobody says 8 months pregnant. So why are you holding on to this phone? It's not, they're not involved. Plaintiff pleaded with Detective Oliver to return her cell phone immediately because her children and her doctor had no other way to get into contact with plaintiff other than her cell phone, but Detective Oliver refused. Finally, plaintiff's cell phone was returned to plaintiff 3 hours later. And here's the wonderful thing. Plaintiff recorded this conversation. So we're going to hear some recordings. I want to hear some recordings. We don't have them yet, but I want to hear some recordings. On February 27th, 2023, plaintiff appeared for her probable cause conference in the 36th District Court before the Honorable Alaya Sabri, and plaintiff demanded to hold her preliminary examination. The preliminary examination was scheduled for March 6, 2023. On March 6, 2023, plaintiff appeared for her preliminary examination, and the Wayne County Prosecutor's Office dismissed the case against plaintiff for insufficient evidence, i.e., hey, this case looks like it's a tire fire. I don't want any part of this tire fire. Let's kill this right now. So, count 1, false arrest and imprisonment in violation of the Fourth Amendment. Now, I'm just going to note here, when we go back and look at the lawsuit, they sue the city of Detroit and Ms. Oliver. You know who they're not suing? They're not suing the officers who effected the arrest under the warrant. Why? Because I don't think they'd make out a claim on those officers. Those officers weren't the people doing the investigation. So they would have no good way. I think that's entirely reasonable of counsel here. Makes sense. And it also shows that they are being targeted in their claims. So Fourth Amendment basically says that you are secure in your persons against unreasonable seizures, and no warrants shall issue but upon probable cause supported by oath or affirmation. In the warrant affidavit, Detective Oliver omitted the fact that plaintiff's facial recognition photo was 8 years old and plaintiff's recent driver's license photo was available. I think mentioning that that the photo was 8 years old was a critical thing to mention, because I'm gonna say an 8-year-old photo may or may not look anything like somebody. I've been at YouTube for 2 years. Like, I've been doing this for about 2 years. Go back and look at my early videos, and what you will see is me with very short hair, much shorter hair than this, because I wasn't growing it out at that time. Would somebody recognize me with short hair? Maybe. But I also don't, I'm not a person who has experienced a whole lot of like facial aging rapidly. Some people do. You just don't know, right? Lots of people look nothing like their 8-year-old self. Somebody says, why are you growing it out? I started growing it out in COVID times because they stopped with, like, they shut down all the hairstylist places. And then I keep growing it because it annoys some people. Also, I kind of like it. There are a couple of times that it annoys me. It annoys me sometimes when I'm trying to go to sleep, if my hair flops in my face and it's like, trying to sleep, not inhale hair. And sometimes when I'm doing stuff with like rifle straps or so forth, but then I just, then I'll rock a ponytail. So if I'm doing firearm stuff, I'll often ponytail it up. Similarly, I'll throw it into a ponytail if I'm doing anything with like a lathe or power tools, because the last thing I want is the long hair to end up in a power tool, because, yeah. I don't remember, what kind of law do you practice primarily? Criminal defense and firearm. So, yeah. All right. Detective Oliver deliberately omitted facts because the magistrate would possibly have denied the warrant. I don't know that they're going to successfully make out the deliberately omitted, but they're certainly going to argue that in this. Somebody's saying, can I explain paragraph 82 more? So this is the Fourth Amendment to the United States Constitution, which guarantees no warrants shall issue but upon probable cause supported by oath or affirmation. This was a big deal because before the Fourth Amendment, what they used to do was they used to just issue warrants because they felt like it. They used to issue warrants because they, basically because they were like, yeah. Oh, and apparently I've been at this 3 years. I lose count. So yeah, this was a restriction on government power. It said basically you can't go arrest people unless you can convince a judge that there is reason to do so. That's basically it. So the omitted facts were material in finding probable cause to obtain a warrant affidavit for plaintiff's arrest. Yes, they were. Now, I also want to note that, at least in most places, when you're applying for a warrant, because it's an ex parte application, which means that the other side isn't there to present their case, right? It's ex parte in the sense that one person, is there. There's often a requirement to provide some additional, or to provide some relevant information, at least where I am. You're required to provide relevant information that that applies, right? Whether it's helpful to you or against you. That doesn't. Now, the key thing is that you're not required to do additional investigation, i.e., if they aren't required to do any further looking into things, but if you already know something, you are required to put it in. That's kind of the distinction there. So it's not like, well, if you had looked this up, they're not required to look anything up, but they already knew all of this beforehand. And no, I'm not going with a man bun. Jeez. No, I'm not a man bun fan. So malicious prosecution. Plaintiff incorporates by reference the above paragraphs, i.e., we're not repeating everything. Detective Oliver initiated the criminal proceedings against plaintiff by submitting a warrant for robbery and carjacking. Detective Oliver lacked probable cause to initiate the proceeding. On March 6, 2023, the criminal proceedings were dismissed in plaintiff's favor for insufficient evidence. Detective Oliver's actions appeared to be driven by malice towards plaintiff. They're never going to make this out. This claim is too far, I think. As a consequence of the proceeding, plaintiff suffered a significant deprivation of liberty as she was given a $100,000 personal bond and was not allowed to leave the state following the arraignment. Also, not a huge deprivation of liberty, unless she was planning on leaving the state. But I don't think they're going to establish that this was malice. I think they're just, this to me looks like sloppy police work and looks like they got overly committed. Like, I solved the crime, and they don't want to go, oh, wait a minute. No, we didn't actually solve the crime. Because the not solving the crime when you thought you had is disappointing. I think that that's really what was going on. It's just like, I am disappointed. And they didn't want to give that up. Count 2, violation of public accommodation of public service for defendant Detroit and Detective Oliver. So, was denied full and equal enjoyment of public service because of race. So this is going to be an argument that things are racist because they're using the facial recognition is where this is going. Defendant Detroit Police Department is a place of public accommodation, a public service, and law enforcement agency as defined in the Elliott-Larsen Civil Rights Act. Oliver is a person as defined in the Act. So Detroit allowed Detective Oliver and others to engage in a pattern of racial discrimination of plaintiff and other black citizens by using facial recognition technology practices proven to misidentify black citizens at a higher rate than others in violation of the equal protection guaranteed by the Elliott-Larsen Act. All right, so this is basically saying they're taking a run at facial recognition everywhere. So they're basically saying, listen, this system itself is racist, and therefore they need to not do it, and they need to get paid. I actually think that they can quite possibly establish this. They're just going to have to bring it. This is going to be where you hear from tons and tons of experts, because one of the things that has been identified over and over and over again is that these systems do suck at identifying black faces. And the thing is I love this I love this argument. I love this because I think this is fantastic, because if they can shut down the use of facial recognition, it means that I can walk around Detroit without necessarily being, picked up and part of a police investigation. So somebody said that it's insane. I disagree. If you're using a system that targets black people, or ends up with more misidentifications, that is a problem with the system, and using it can be an issue. Defendant Detroit violated the act and deprived plaintiff of her civil rights by, among other things, subjecting plaintiff because of her race, arresting plaintiff, and other inconvenient acts which had the purpose and effect of denying her the full benefit of public safety of the police department and denying plaintiff full and equal access to the use and privileges of public accommodations, public service, and police protection. As a direct and proximate result of the conduct of defendants, plaintiff has suffered injuries and damages, including past and future pain and suffering, embarrassment, humiliation, mortification, economic damages, past and future emotional distress, and deprivation of equal protection and due process of law. There's another false arrest and imprisonment, which we're going to skip over a little bit, but this is again based on the facial recognition and saying that they had failed to guard against the errors that are there. So basically, you guys knew that these systems have, it says that considering the substantial emphasis defendant Detroit's police department placed on facial recognition searches, the failure to implement proper regulations for the technology's use and adequately train its employees reveals a state of deliberate indifference toward the potential harm faced by individuals erroneously identified. The inclusion of these individuals in six-pack photo lineups significantly increases the chances of further misidentification, especially since their appearance in such lineups could closely resemble the actual suspects due to prior identification as potential matches by the facial recognition technology. This sentence is incredibly important. Incredibly important. So, the inclusion of these individuals in six-packs photo lineups significantly increases the chances of further misidentification, especially since their appearance in such lineups could closely resemble the actual appearance or the actual suspect due to prior identification as potential matches by the facial recognition technology. So, what does this mean? Well, the police run your face through a, or they run a criminal's face through the database, right? Somebody who has committed some sort of crime. And it comes to you. It generates you. Like it spits out you as a match. But you're not actually the criminal. Why did it spit out your face? Well, it's not random, right? It's not like it just got a random wrong person. In fact, it got a wrong person who looks similar to the face they're looking for. And so then when you show that similar face to a, to the actual victim, they're much more likely to pick that one out, even though it's wrong. Even though it's the wrong face, you are basically screwed. And there's a further wrinkle on this one that is important. Because you have now shown, my picture, which is like the wrong picture. We've already agreed I'm not the person who did it. Because they show them my picture, now we are actually contaminating that person's memory. And now their memory of this one is going to be tainted by having seen me. To the degree that, let's say the police, and this has happened, let's say the police then find the real person, right? They, through some means, like DNA or something, or they just, they search the car and it turns out that the real person's wallet is in there. They find the real person and they ask the victim to identify who robbed them. There's a very, very good chance that they will pick the incorrect identification that they just picked out of a lineup instead of the real person once you've shown them that bad lineup. You can actually contaminate their memory to the point where they will prefer the wrong answer versus the right answer. So what does that mean? Well, amongst other things, there is no way in hell that whoever Trinidad is, they're not going to jail on this one unless they confess. If they make the mistake of confessing, then they're going to go to jail. Don't talk to the cops. You never know if there's, a serious problem with the case against you. So if, let's say dude remembers, oh yeah, hey, yeah, I just remembered, I know where Trinidad lives. Or, hey, I just remembered when me and Trinidad had sex, because that was part of the story, I saved the condom. We can run DNA off that. And so the police run that and they get a DNA hit. Well, great. They find the person. But then they've got then they've got the victim who's already ID'd someone else. You're just not going to be able to get to a conviction on this. They've ruined their case. Yeah. Computer says this person is 89% likely to be mistaken for the perp, assuming inadequate lighting or distance in time from the event. They're basically picking the most likely to be mistaken for the perp person it can, is essentially what these systems will be doing. So, all right. More false arrest and imprisonment. And that is that Detective Oliver was aware that plaintiff had not committed the crime prior to plaintiff's arraignment and failed to take any actions to have plaintiff released. Because I got to say, if I'm Detective Oliver and they bring in this person for an interview and she's 8 months pregnant, I'm like, whoa, let's get you out of here. We have screwed up. We have the wrong person. And, yeah. And yes, the pups are running around in the background having a great time. They are currently chasing each other. So, malicious prosecution. So basically, they continued the proceeding without probable cause, as they learned on February 16th at the Detroit Detention Center that she was not the individual that committed the crime of robbery and carjacking because she was 8 months pregnant, but she made no attempts to stop the criminal proceedings. So, and I gotta see, it depends on the definition of malice here. I think what Detective Oliver is going to say is, well, I didn't know that the person couldn't be pregnant when they did it. Like, I don't know. I don't think the malice is going to be held out, but I'm going to have to look into the definition of what malice is in that area, because maybe. I see. It sounds like Detective Oliver assumed that she was guilty and not innocent. That's really common. Police tend to, once they have a suspect, they just zero in on them. And it's a real problem, tunnel vision, where it's like, it's all you can see. Are she and the baby okay? Yes, so far as I know. I mean, she went to the hospital, but yeah. All right. Plaintiff incorporates the above in the manner described more fully above. Detective Oliver engaged in extreme and outrageous conduct for like the reasons why above, but she knew that she had to know that there was a high probability their conduct would cause severe emotional distress to plaintiff. Most people find it extremely stressful to get arrested. Most people do. If you don't, you're probably the sort of person who's in the habit of getting arrested. Like, there are people I know who's just like, I called up a client and I'm like, hey, there's a warrant for you. And he's like, oh, again? All right. And, no big deal to that guy. But if I picked a random person out of chat and was like, you're going to jail today, I bet they would find that to be extremely stressful. Especially in a situation where you're like prepared to, prepared to take your kids to class. All right. So injuries, including but not limited to severe emotional distress. What does she want? She wants compensatory, non-economic, and economic damages that might be proven at trial to compensate plaintiff, i.e., money. Exemplary/punitive damages, as may be proven at trial, i.e., more money in order, but this is not money to So the first category is money to replace the damages that she lost. You know, medical bills, therapy bills, um, you know, whatever the court values the loss of quality of life at, all of those things. She wants that. But the second category is there should be some additional money. And this is basically, we're 10 minutes away. This is FU money. This exemplary / punitive damages are money because somebody's conduct is so egregious that that the court should additionally punish them. Reasonable attorney's fees, costs, and interest pursuant to 42 USC 1988, i.e., pay for her lawyers, and such other and further relief as appear reasonable and just under the circumstances, which means anything else, court, that you feel you want to give me, I have asked for it. And this is an important ask. Like, you always put this in. You always put this request in. And the reason why you put this in is that you don't want the court to say, well, and I would have also given you something else, but you didn't ask for it, so I'm not giving it to you. This just basically says, court, if you want to give me anything else, I want that too. And yes, somebody was saying, is the jury trial demanded? Well, sort of. There's a demand for trial by jury. A little bit of a typo. A demand for a trial by jury. But yes, she demands a trial by jury. There's a good question. Does she need to prove software is racist in order to win? She does if she wants to win the claims related to the software being racist. However, she can win the other claims for that. I'm just going to note, it's really common that lawyers make spelling mistakes in these things. And it's in fact getting more common because, sometimes people are, they just run it through a spell checker and a lot of people don't actually go through and proofread themselves anymore or give it to a junior to proofread. So, yeah. All right, give me 1 second. I need to cough. Sorry about that. Software racist. It's possible, right? You can end up with software that is designed to make decisions that makes bad decisions, right? It is really a thing that happens there. So it is entirely doable. I nearly released a document with the word pubic instead of public. I have seen, more than once, I have seen people send out an email that ends with retards. And then, it's like, this is why you don't want to use regards in your, sentences, because the G and the T are right next to each other. And your spell check won't find that. It won't spot that. It'll just think that's the word that you want to use. So, if you've got technology that makes bad decisions, it's your choice to use it, right? It's your call to rely on it. And so, another example is, let's say you had a medical test, and that medical test, for whatever reason, doesn't work as well on, let's say it doesn't work as well on white people. But you decide to use it anyway. And because of that, it makes some bad decisions and ends up causing people some serious difficulty. If you knew that this software had this problem and you chose to use it anyway, that's on your issue. So, yeah. All right. And I see people saying that the programmers create bias. In the case of facial recognition, there are two problems. I went over this before, but there's two problems. One of the problems is that they're a lot of these databases are largely used with are built with white faces. So that is one source of problems. But another source of problems on these things is that just lighting issues, in the sense of, my face has pretty good contrast in terms of like you can see all the shadows and shapes and so forth. It can be less easy to see it on different shades of skin. So they've tried doing things like making facial recognition systems using entirely black faces to try to be better at that. And they still struggle. It's just like, this is a problem that you're just getting different data, and it's stuff that the computer systems are having trouble processing. So, I mean, it's just, you got to do better at this, right? That's the thing. So, all right. Yeah, and here's the other thing is a lot of it was being built off of white college students, which also means that it can sometimes be really awful at old people. The thing is the software itself doesn't have opinions, right? The software doesn't know anything. It's that using software that generates, generates bad results with a particular group can be a racist decision by the people. That's the thing. So, it's not an issue of like, hey, because nobody cares what the software is. The software itself isn't a claimant. You can't actually sue the software. You sue the people who use the software. So that's where it matters. All right, let's go and look at some super chats here. Laura Christine, thank you for 10 gifted memberships. Koru, thank you for 5 gifted memberships. Lori Linney, thank you for 5 gifted memberships. Much appreciated. And Hedgehog in Space, thank you very much for the new membership there. Much appreciated. Casey Cat, don't forget to smash that like button. Always a good thought. Law and Lumber, resurfacing from hiding to say hi. What did I miss besides your snark and spice? We also went over SBF. Although I'm sure you're going to go over SBF in more detail and more, more detail there. Yeah, and this is it. If you know your software is an issue, you yourself have to correct for it. That's exactly it, right? All right. Carolyn J. Rubin, woohoo, love all your content. Thank you very much. And unfortunately, sampling bias causes bias in models. That is true. All right. Let us, and this is another one. Wasn't there a big stink a few years ago with Apple iPhone face unlock not working well with Black and Asian faces? Yep. And it's funny because sometimes the solutions for things like an iPhone are to make it more generous at recognizing. And therefore, when you make it more generous at recognizing, you also make it easier to unlock someone else's phone. So that's the issue. All right, we are going to do a swoop. And we're also going to run this. Because we are 2 hours in, it is now spicy time. How are people holding up? I can feel a little bit of a cough, but that is we're still good to go for now. Sue Candle, thank you as well for 5 gifted memberships. And Gwendolyn, programming needs to be rewritten, possibly. Yep. that is an issue. No, we're not going to talk about Dune. It's just that's my spice. The spice must flow sort of transition. There is a bit of a Dune connection, however, for our next case. Now, this one is actually a bit of an older case. It was started back in 2022. So we're looking at this one again because they've actually amended this one to add a new person. So let's go over this lawsuit because this one I think is fun. This one is about NFTs. And so this is Johnny Johnson, Ezra Buckweg, Mario Palombini, and Adam Twitcher, and individually and on behalf of all others similarly situated. What does that mean? It means that this is a class action lawsuit. And who are they suing? Giant long list of people, but this giant long list of people includes Paris Hilton. It includes James, also known as Jimmy Fallon, and his company, Electric Hot Dog Incorporated. It includes Universal Television. It includes Justin Bieber. It includes also Adidas America, Adidas Ventures. It includes all sorts of things. Now, they've also added Sotheby's, the auction house. So that is a recent change as they've added this. But who is the main villain alleged to be in this one? Well, that is Yuga Labs. And what is Yuga Labs famous for? Yuga Labs is famous for the Bored Ape Yacht Club NFTs. Bored Ape Yacht Club. Now, all of these people who are named basically said, look, at how much money I spent buying a Bored Ape NFT. But this lawsuit alleges essentially a really complicated conspiracy to convince the public that NFTs were worth something. Which, if you are still invested in NFTs, try to sell them to some other sucker. Because those... I'm joking here, because I don't want to give you any financial advice or anything. But, like, why would you buy an NFT? It makes no sense. So, let's have a look. And this is 221 pages. You know how many pages we're not going through? We're not going through all 221 pages because, oh my God, no. We're going to go through like the basis of what they're saying is happening here. And NFTs are dumpster fires right now. NFTs were dumpster fires from the outset. The whole idea of NFTs was stupid. It was, we are going to link, we're going to sell you a link on the blockchain to a picture that is not on the blockchain that who knows whether it's going to connect to, and you can, yeah. Blue Smoke says they're worth whatever they can be sold for. Sure, but they're a tulip bubble. Yeah. This is a good example. NFTs are Beanie Babies for tech bros. Yep. That's a good... yeah, and if you remember Tulip Mania, or if you've looked into Tulip Mania, Tulip Mania was this brief time when people were spending huge money to get single bulbs of tulips. And then eventually it crashed. All right, so basically what happens in this lawsuit, the basic summary, the bottom line is that a bunch of people bought NFTs, spent a freak ton of money on them, and then were very sad when they lost huge money. Very, very sad. Because they lost a ton of money on this. And yeah. Now, there's a whole bunch of celebrities listed. I don't know half of them because I'm not really a major celebrity follower or anything like that. But they start off with a great quote. Celebrities and NFTs are a match made in hell. Somehow, star endorsements have found a new low. Now, I'm just going to talk a little bit about endorsements, which is endorsements are typically a very bad way of making buying decisions because most of the endorsements you will see out there are purely endorsed on the basis of this person was willing to give me money for it. Whenever I do a review, I will note if I recommend that I like something, it's because I'm willing to use it myself. I'm willing to do something with it myself. And I'll also tell you exactly every review video that I've done, or endorsement-ish video that I've done. I have told you exactly how much I've been paid for it. So, like when I did a review for that flashlight, I told you exactly what I got for it, which was one flashlight. When I did a review for that rifle scope, I told you exactly what I got for it, which was one rifle scope. You got to be very much aware of all of that because, most of these things are scammy. So, plaintiffs bring this action on behalf of all investors who purchased Yuga's non-fungible tokens or ApeCoin tokens between April 23rd and the present and were damaged thereby. And Yuga's various collections of so-called Bored Ape NFTs, including the Bored Ape Yacht Club, Mutant Ape Yacht Club, Bored Ape Kennel Club, Ape Coins, and Virtual Land in the Other Side, aka Other Deed NFTs, are collectively referred to as the Yuga financial products or the Yuga securities. Why does it matter that they're calling them securities? Well, securities are heavily regulated. Heavily regulated. And if you're trading in securities, there's all sorts of rules about what you can do and what you can't do and how you can advertise them. And somebody is saying, what in the world is a Bored Ape? I guess I need to show a Bored Ape NFT. Let's find an image of a Bored Ape. And I'm just going to mention that people spent millions for these. All right, so I'm just pulling up the Wikipedia page. I'm gonna see if I can zoom in, and then I'm gonna share it. All right, we're gonna stop the screen there. We're going to present, share screen. So these are Bored Apes. They're various designs of silly monkey pictures, basically. And you might be saying, oh, well, at least I own the picture. Like I own the copyright to the picture. You don't actually. You own, and you don't actually get a copy of the picture either. What you end up owning is you own a link to the picture on the blockchain. So, like, you buy a link to a silly looking monkey, and yeah, this is it. You're basically buying a receipt. So the only thing you're buying is essentially the ability to tell other people who are interested in these silly monkey pictures that you own the NFT for this particular silly monkey picture. It's like being able to, to dick wave about, I own this pointer to this silly monkey, but like, this is the dumbest thing on the planet. And why did people buy these? They bought these because they thought that they were going to increase in value indefinitely. They thought that this was going to be the answer to this. I see. What can you do with it now that you own it? Nothing. You can sell it to some other sucker who wants to buy a Silly Monkey link. And the other thing is like, people, if you don't get it, then you get it. If you don't understand this, then you understand this better than most people. Because if you look at this and you say, this is stupid, this is idiotic, I don't know why any human being on the planet should watch this, or would want one of these, then congratulations, you understand NFTs. That's basically it. All right. So, let's have a look back at this lawsuit, because we want to find out why people are getting sued over silly monkeys. Why? What is the silly monkey stuff here? So, NFTs, the pet rock and chia head of the 2020s. At least you actually own an object with that. All right. Celebrity promotions of cryptocurrencies are fraught with problems. Yes. If somebody came to me right now and was like, Runkle, do you want to help pitch our coin? I'd be like, no, go F yourself. And if somebody was like, hey, Runkle, I want to set you up with a Runkle coin, I would say, no, go to heck. This is ridiculous. If somebody said to me, hey, let's, at one point, I actually thought about intentionally creating the dumbest NFTs on the planet. And so here was the idea I had for NFTs was I will create a website URL and I will put up 100 images on it, 100. I will sell those NFTs, the links to those images. So now people can buy those. And then I will intentionally let the domain lapse so that it can get picked up by any random moron on the internet. And then they can replace those whatever pictures with whatever they want, whoever buys that. So that was my idea. And it was like intentionally making fun of the idea of NFTs. But yeah. And we've got Emily in the chat there. Too late on dumbest NFT. Didn't Paul Brother do Dink Doink? Yeah. One of the Paul brothers, I think, mentioned, he said, like, this is the NFT I spent $500,000 on, and it's now worth like $25. So yeah. Yeah. And this one makes sense. Some of the NFTs served as a ticket to get event tickets, merch, and other stuff. The DEP NFTs came with a signed print of the NFT and entry to a private creatives club. If it actually gets you something, then it's not quite as dumb. All right. So, celebrities and others are using social media networks. Oh, and Emily, did you cover this case like 2 years ago? Because this one was just updated to add Sotheby's, but it seems like it's right up your alley. So if you haven't covered this one, I would be surprised. So celebrities and others are using social media networks to encourage the public to purchase stocks and other investments. These endorsements may be unlawful if they do not disclose the nature, source, and amount of any compensation paid directly or indirectly by the company in exchange for the endorsement. And there's a clever scheme that they're alleging here. According to The Atlantic, celebrity endorsements of a product, a brand, an idea, a haircut have been around for ages, but they've become especially thick on the ground in recent years as stars have developed their own direct advertising channels on social media. For people with something to sell, the celebrity's fan base provides an easy, responsive audience. So, then we get this, they're alleging a vast scheme between a blockchain startup company, Yuga, a highly connected Hollywood talent agent, defendant Gary Osiri, and a front operation, MoonPay, who all united for the purpose of promoting and selling a suite of unregistered digital financial assets. So they say that they together devised a plan to leverage their vast network of A-list musicians, athletes, and celebrity clients and associates to misleadingly promote and sell the unregistered Yuga financial products. So they're alleging basically that from beginning to end, there was a giant deception on the public. So investment in Yuga's flagship NFT collection, the Bored Ape Yacht Club, purportedly gave investors memberships into the Bored Ape ecosystem, i.e. the overall brand and its synergistic relationship between the Yuga financial products and related applications. The underlying marketing message was simple. Joining the club, i.e. buying a Yuga NFT, buying an ape, brings investors status and provides them access to events, benefits, and other lucrative investment opportunities exclusive to Yuga financial product holders. I'm just going to say an investment opportunity, like the opportunity to have exclusive access in investments with people who also bought apes. That's either a target-rich environment if you're a scammer, or else like the worst possible place to be if you are like trying to look for legitimate people to work with. But yeah, if you were a scammer, it's a target-rich environment of like people who've already been scammed for millions of dollars. So the perceived exclusivity of Bored Ape Yacht Club's membership was driven by endorsements of highly influential celebrities. But this purported interest in an endorsement of the BAYC NFTs was a sham manufactured by Osiri and MoonPay at the behest of the company and executive defendants. While the promoter defendants publicly touted their high-dollar purchases of Bored Ape Yacht Club NFTs, the truth is that they were given the NFTs for free, often along with additional compensation, in exchange for promoting the Bored Ape Yacht Club NFTs to an unsuspecting public. Whew. So basically, the allegation is that they were promoting securities without telling everyone that they were getting the stuff for free in exchange to be hired promoters. This could get them into a lot of trouble if it's backed up. So they're saying that they needed a way to discreetly pay their celebrity cohorts, and so they're alleging that that's where MoonPay comes in. That MoonPay basically sets themselves out as a white glove service designed to help the super rich and celebrities buy NFTs without all the hassle of setting up a wallet, buying crypto, using that crypto to purchase NFTs, and then taking custody of it. But in truth, they're saying that they were using this as a way to compensate the promoter defendants for their promotions of the Bored Ape Yacht Club NFTs without disclosing it to unsuspecting investors. Moreover, certain of the promoter defendants failed to disclose that they themselves had equity interests in MoonPay. And think about this, right? Think about how this would work, how this would look. You've got these two halves of this business, right? And so MoonPay takes like $2 million and then pays that for an NFT to the Bored Ape Yacht Club, Yuga, and then Yuga can just give them the money back. So no money actually moved, but it looks like this Bored Ape moved for $2 million. The celebrity gets it for nothing. So in effect, what you've done is you've just taken money. No money has actually moved. No money has actually changed hands, but you have just faked a $2 million transaction in order to sucker the next guy into thinking that this is a $2 million product. If this is sounding fraudulent, well, that's kind of what they're alleging. That's kind of what they're suggesting here. That's kind of their feeling on all that. And was that? And Emily, let me know if you've got any interest in this case. I can send you the case as well. But this is one. Oh, and welcome. Thank you for the membership. Glad to have you aboard. This one is looking super super sketchy here. So they note manipulative trading practice were also implemented by insiders in conjunction with the celebrity endorsements in order to further generate artificial trading volume and price inflation. Now, this is a scheme that has long been known in the art world, and this is a scheme for money laundering. So, how it worked in the art world is, let's say you've got $2 million of drug money. And the problem with $2 million of drug money is that you can't spend $2 million of drug money because, it's illegal money. It's just mystery money that has no source. So what you instead do is you find some young artist, somebody who's talented, but is not going to go anywhere. And you say, hey, how would you like to make some money? And they go, ooh, I like money. And you get them to put up a painting, and they put up that painting for auction. And then you pay for that painting 10 grand. And you now have this painting that is ostensibly worth 10 grand. The artist receives the 10 grand and immediately gives it back to you under the table. So you've got your money, back there. But then you sell this painting on to someone else for 9 grand, and now you've got 9 grand of clean money because now you've sold this painting. You can keep, or you sell this painting for the drug money, and now you've got 9 grand of clean money because it's been washed that way. But all of these transactions are fake. The money is just being passed around without any actual intention to transfer it. The whole point is just that the money stays where it's at. That's kind of what they're suggesting. So they also say that they went on and they say the staggering profits of the Bored Ape Yacht Club NFTs were not enough for the company and executive defendants. Next, they cut out the artifice of the NFT altogether and went a more direct route to making money. They created their own out of thin air, and that is Ape Coins. So they basically said that anybody who owned a Bored Ape Yacht Club NFT would receive an airdrop of Ape Coins for membership in the club, but they were also selling Ape Coins on the side, is the allegation. So, they say that they raked in millions of dollars, but investors were left with staggering losses. Again, it's hard to feel bad about this. And King Ginger, I will look at that one because video gaming is totally my speed, but more than one person may look at that one. It's hard to feel super bad because you've got these people who are buying silly monkey pictures, right? And at the end of the day, you're like, okay, you bought a silly monkey picture or a link to a silly monkey picture. That's kind of on you, right? Because shouldn't you have known that that maybe this silly monkey picture was a scam? It felt like a scam to me. I can tell you, a friend of mine was basically saying, listen, I want you, he's like, you got to get into this NFT stuff. And I was like, okay, explain it to me. And he explained it. And I said, that sounds like I'm being ripped off. And he says, no, I must be explaining it wrong. And he explains it again. I'm like, this still sounds like I'm being ripped off. And he's like, no. And I'm like, dude, I represent fraud clients for a living. This sounds like their explanations to their suckers. And he's like, no, it's for sure going to make big money. He lost a lot of money on silly monkey pictures. I don't think he actually owned any monkeys, but like silly, stupid pictures. Lumber saying, have I turned you into a crypto fascinated attorney? Kind of, although I always had an interest in making fun of silly monkey pictures. And it's really fun to see the silly monkey picture stuff starting to just get blown up in courts. So I want to see what all of this turns into here. So they've got various allegations. Again, this is 221 pages. I could maybe do a stream going through just this lawsuit. But the recent development, this lawsuit was filed a while back. The recent development is that they added Sotheby's, the auction house, and that's kind of an exciting place to be there. So let's jump to looking at how Sotheby's is in the loop, because some of these things were auctioned via Sotheby's auction house. So the misleading promotion and sale of Yuga securities. So the company began a multi-pronged scheme to promote additional sales of the Bored Ape Yacht Club NFTs, of which Yuga would take a 2.5% fee on every resale. So this is the other thing about Silly Monkey Pictures, is that the Silly Monkey Pictures, often they're set up so that it's not just that you get a sale or that the original creator gets money each time, like on the first sale, but they also often get money on each additional sale, which is not how paintings work. Like if I sell Rob a painting and then it goes and, then that painting doubles in value and Rob sells it, Rob keeps all that money. Whereas if I sell an NFT, it actually automatically pays me a cut each way along or each time along, which is ridiculous. First order of business for the company and its founders was to create an air of legitimacy around the Bored Ape Yacht Club NFT collection to generate investors' interest and hype around the Bored Ape brand. To do this, Yuga colluded with fine arts broker defendant Sotheby's to run a deceptive auction of a lot of 101 Bored Ape Yacht Club NFTs. This special sale was called Ape In. Wow. Wow. In the lead up to the Bored Ape Yacht Club, Sotheby's representatives misleadingly promoted both the auction and the Bored Ape Yacht Club NFT collection on the Sotheby's social media accounts and with statements to various news outlets. These promotions were amplified and further disseminated by the company through its various social media accounts. Now, I gotta say, if you are gonna, Sotheby's, as an auction house, has a really good reputation and so forth. Why would Sotheby's ever venture into what seems like clearly scammy stuff? So, yeah. Sotheby's head of contemporary art auctions, Max Moore, posted an advertisement for the Bored Ape Yacht Club auction from his Twitter account, which included an animation of gold Bored Ape walking his golden Kennel Club dog, along with the Sotheby's and Bored Ape Yacht Club logos and the dates of the auction. Gotta love social media managers. Sotheby's promoted the Bored Ape Yacht Club auction as a landmark event for the storied arts dealer. It's official. For the first time in our 277-year history, apes and kennels are storming Sotheby's. Maybe the last time, too. I hope it's the last time. So the Bored Ape Yacht Club sale starts September 2nd, Ape In. The promotion included the same animated video of their gold Bored Ape walking his golden Kennel Club dog from Moore's earlier post. They also changed their official profile picture to a golden Bored Ape in front of a golden Bored Ape Kennel Club dog to publicize the auction. Yeah. So they said that Bored Ape Yacht Club and Bored Ape Kennel Club have paved the way for what NFT art communities can be, i.e. a giant scam people lose their money on. Whether it's your online identity, a shared culture, or you just want to ape in, the Bored Ape Yacht Club's sale starts September 2nd. So yeah, Sotheby's was really pitching the Silly Monkey Pictures. And I mean, somebody out there is going to have to explain. Somebody out there is going to have to explain to, to the government, their business losses. Listen, my business invested in a $5 million monkey picture, And all of that is now losses. All of that is now losses, and there is no more money. And the government's going to be like, sounds like fraud to us. Because, yeah. So, yeah, they were basically telling people, like, this is your chance to own one of these NFTs, like trying to spin up fear of missing out. And Moore claimed that the Bored Ape Yacht Club NFT collection had made it to the gold level of art by being offered for sale by an art dealer of Sotheby's status. Ooh. Stating, and here's the post. What is it? What is it? So Max Moore Art, head of contemporary art at Sotheby's, said it today. Whether you think we need auction houses or not doesn't matter. What matters is that we made it. We effing did it. And yeah. So notably, Moore, during the promotion of another NFT auction conducted by Sotheby's, previously acknowledged that the stamp of approval from a Sotheby's endorsement can induce investors to make purchases of NFTs. I do expect some collectors who maybe have never purchased an NFT to make their first NFT purchase in this sale, given that it's a Sotheby's sale. And I feel like there were people who probably said, oh, this tells me that it's not a scam, that now, that now this is a real thing because Sotheby's is in on it. Now, I'm wondering, when are they going to get to the aspect of Sotheby? Because really, if Sotheby is just auctioning stuff, that's not the biggest thing. But we need to find out where there's sort of the kickback here, or their knowledge. Now, in the end, Sotheby's claimed to have sold a lot of NFTs to a purportedly anonymous buyer for $24.4 million. This bid far exceeded the upper estimate of $18,240,000 per Bored Ape Yacht Club NFT Sotheby's had publicly predicted. This price was more than $100,000 more than the floor price for Bored Ape Yacht Clubs at the time. 24.4 million on Monkey Pictures. You know what I could do with 24.4 million? I would buy 0 Monkey Pictures. 0 Monkey Pictures. And they said that the winning bidder was a traditional collector, and they think it was Max Moore that said that. Now, I'm just there's a lot of pages to this, and when I went over it, I'm trying to find where I am here again. And they said that winner of the 24.4 million lot of 101 Bored Apes is a traditional buyer and had to KYC, which is know your customer. Know your customer rules are basically there because of money laundering. Who bought this? You got to know who, because you got to know if there is money laundering going on. That's what that's about. Yeah. I can actually say that you probably got a worse deal if you bought NFTs than if you bought whatever OnlyFans model's bathwater it was who was selling it. Because at least the bathwater is a physical object. Yeah. So and they said that it was a traditional art collector and said that such a feat hadn't happened in an NFT auction before. All right. And they continuing on to, tout this sale. And legacy art collectors were also heavily involved in the bidding. So they're promoting the legitimacy of this, right? They're basically saying NFTs are real art because there's a traditional art collector buying it. Well, let's see where the scam lands. They also declared that NFT market is not a bubble, explaining People were talking about a bubble in March, in June, etc. And then we see that the market is even stronger today. So I think they've been proven wrong. I think it's a very organic market with great collectors who have a great appreciation of art. Who's feeling that it was not a bubble? NFTs have lost like 95% of their value in many cases and like 100% of their cases value in other cases. So yeah. I see somebody said that something was a great poll question, but I missed the question. I guess it's probably about the which is the better investment. Let's do that. Which is the better investment? NFTs, influencer, bathwater, liquor. There we go. Oh, I should have added farts in a jar. You know what? We're gonna end the poll early. We're gonna start the poll again. Best investment, NFTs, influencer, bathwater, farts in a jar, or liquor. There we go. So now we've got a poll going. Which is the better investment? I know which one I'd buy. All right. So they keep going on. They keep pitching it. And so shortly after the Sotheby's auction and its related promotion, they hit an all-time high floor price of around 43 ETH per NFT. And so this chart shows how much impact the Sotheby's auction and its promotion had. So here's the auction, and you see it goes up and up and up, and then back down. Okay. This initial boost, however, now we're getting to the scam, was rooted in deception. Sotheby's representations that the undisclosed buyer was a traditional collector had misleadingly created the impression that the market for Bored Ape Yacht Club NFTs had crossed over to a mainstream audience. The company and its founders likewise touted the Sotheby's stamp of approval that the auction was above board. But the reality of the winning bid of the Sotheby's auction exposes the falsity of these statements. In truth, it was not a traditional buyer that made the winning bid in the Bored Ape Yacht Club NFT auction, but rather the now defunct cryptocurrency exchange FTX. FTX. Sam Bankman-Fried and his hair is back in the game. So if you thought Sam Bankman-Fried was not going to be involved in this, yeah. FTX has several deep ties to Yuga, such that it would be mutually beneficial for both Yuga and FTX, as well as Sotheby's, if the Bored Ape Yacht Club NFT collection were to rise in price and trading volume activity. Upon information and belief, given the extensive financial interest shared by Yuga, Sotheby's, and FTX, each knew that FTX was the real buyer of the Bored Ape Yacht Club NFTs at the Sotheby's auction at the time. That Sotheby's representatives were publicly representing that a traditional buyer had made the purchase. Ooh. According to the transaction data available on the Ethereum blockchain following the auction, Sotheby's transferred the lot of Bored Ape Yacht Club NFTs to wallet address, and they provide the address. I'm not going to read that address because that's a lot of numbers and letters and so forth, which, upon information and belief, is owned and controlled by FTX, which means it's probably soon going to be owned and controlled by like the US government. The government ends up owning a lot of monkey pictures at various points. So This wallet previously sent 13 Ethereum to a Blockfolio/FTX US exchange in April of 2020, prior to the launch of FTX US and FTX's NFT sales platform in December 2021. This form of interaction often indicates a relationship between this wallet and the exchange. This they're going to have to back up. Moreover, for the launch of its NFT platform, FTX put out a promotional video that featured more Bored Ape Yacht Club NFTs from the Sotheby's auction. Promoter defendant Stephen Curry, who, as discussed further below, misleadingly promoted the FTX platform and the Bored Ape Yacht Collection NFT collection, tacitly endorsed this joint FTX Bored Ape Yacht Club ad, replying, "Cool announcement video, but my editing skills are missed." Son of a bitch. Runkle of the Bailey. How did I know this would circle back to SBF and FTX? I feel like he is, at this point, like an octopus with a tentacle in every crypto scheme that's out there. So, yeah. Rob, we may have to go over this on Friday Night Frenzy, but the entire thing is 211 or 221 pages. So, maybe not in its entirety. So FTX also promoted it, and as further discussed below, these wallets received millions of dollars worth of ApeCoin under highly dubious circumstances. I always find the millions of dollars of ApeCoin to be one of those sentences that I'm just like, really? Really? How did I mean, you can say it cost millions of dollars, but to say it's actually worth millions of dollars, I go, maybe. So this, like, as I said, this actually was, this lawsuit is old. This lawsuit was a couple of years old. However, what they just did recently was they just added Sotheby's as a defendant. And so the new aspect to this lawsuit is the Sotheby's connection and the SBF connection. And so, I mean, this, based on these allegations, if they're able to make this land, it sounds like there should be more people going to jail over all of this and going to, going to have further trouble. So this one I think is going to be interesting to follow. I'm going to start following this one and seeing what happens. But yeah, there's a lot of interesting allegations on this one. This one is too long to go through in full detail on this stream. I will probably do a full stream just going through this entire thing. But it'll be like a pack a lunch thing because, yeah, that's going to be a while. So here's hoping that we can go over this one in future soon. But I don't want to spend the entire stream on this. And I don't, if I'm going to do this one in a stream, we're going to start at like, 10 a.m. my time. And we're going to go until I drop. I kind of want to make sure that my lungs clear first. All right, let's talk about some other recent developments, some other recent stories and news stuff. And so I will end the poll here. And I see here, what is it? We have the Legally Blonde one we'll probably get to. The Curry Richens I should get to. What is my time zone? Mountain time zone. So, so the poll has liquor at 75%. I like that. Farts in a jar at 14%. Influencer bathwater is at 7%. And NFTs has clocked in at 1%. I feel like there's like 2 crypto bros in the chat. Emily, we absolutely do. Scheduling is just such a tough thing because we're busy people. It's tough. So I feel like the NFTs is probably mostly misclicks, but and maybe like 2 crypto bros in the chat. All right. What is it? Let's what is it? Let's I see Chris Mullen. Thank you for 5 gifted memberships. I'll go over some super chats and so forth here, and then we'll do a swoop and look at our next issue. Chris Mullen for 11 months, almost 12 months. Looking forward to congratulating you on a full year or so. Thank you. Suzanne S., I just keep investing in booze, and by investing, I mean drinking. Cheers. Kristen M96, I could have done robot NFTs. Then again, they're mostly lawyers, so that would have been dumb. Never mind. Love it. Hey, Kristen, I can think of a non-lawyer robot NFT you can sell. We can go halvesies for my creative input. Let's not do an NFT scheme in my chat. Melissa Ritchie, thank you very much for the new membership there. Mountain Princess says, like button. Yes, hit the like button. Thank you very much for the member chat there. Here for years. Thank you for being a member. Much appreciated. And Brandon Shelton says, thanks for all the content. A lovely decompression after losing my grandma to dementia earlier this morning. I am so sorry to hear that. 87 years old. Thanks for the love, chat. I'm sorry to hear that, Brandon, but I hope that we that this is a comfort. So, yeah. All right. Let's do a swoop and look at our next story here. I love the pups. Yes, I should give somebody saying wrench for EDB. That is a good thought. Yeah, there we go. So, wrench added. I don't know if she'll use it, but wrench added. So this is an interesting article from The Intercept. And that is a really concerning development here about DNA databases and what police are doing with them. So these DNA databases are things like 23andMe and various others. They're commercial DNA databases where you might submit your DNA to learn new things about yourself, like what your genetic history is, or in some cases, finding relatives you didn't know existed, which these databases have been a leading source of difficult conversations, because there's a bunch of people who've done these tests and it comes up and it says, oh, hey, your dad isn't who you thought your dad was. That's a fun conversation. That's a difficult thing to have a discussion about. So, what is going on? Well, sometimes these things have been used by governments to, for instance, these governments have then gone on to submit DNA to them, and then they find a relative of the person, and then that lets them connect to it. So they use this to track down the Golden State Killer, because they found this. Now, you can, when you do these tests, opt out of police using them. And if you're going to do one of these tests, you should absolutely opt out of police using your DNA, because otherwise it's basically like giving the police your DNA for use in investigation. But there was a service called GED Match, and it had a bug. It had a defect. There was a security hole. And that allowed the police to do searches based on matches or based on people who had explicitly opted out of sharing their genetic information with police. In fact, they had ways to do searches specifically to, like, on this pool of people who were opt-outs. Now, this, they noted, was something that you couldn't find by accident. You had to actually have done some security efforts to look at it. But there's apparently been at least one match to a criminal where they've actually were using the stuff that's supposed to be unlisted. Ancestry.com and 23andMe both say that they forbid police and the genetic genealogists who work with them from accessing their data for crime-fighting purposes. Note, however, that is with a critical element. Absent a valid court order. Once it's there, once that's out, they can potentially seek a court order in order to pursue it. And then there's Family Tree DNA and GED Match, which grant police access but gives users the choice of opting in or out. Keep in mind as well that when you opt in, you also are opting in your family members, basically. Because if you opt yourself in, then they can tell that somebody is a close relative, like a parent or a sibling. So, now this is a good point. If a member of my family breaks the law and my DNA is used to find them, I fully support that. What if, however, a member of your family does not break the law and your DNA is used to falsely convict them? Because this is a real possibility. Let's say, for example, somebody is found dead by the roadside and, murdered by the side of the road. They're in a ditch. Well, what are police going to do to try to solve this crime? Well, they're going to look around this, this scene of the crime, and they're going to try to see if they can find some evidence. And let's say they find a cigarette butt that is right near the body. Well, that sounds like an excellent clue, right? So they pull the cigarette butt up, they, use tongs, they test the DNA, and they find the DNA match from the person. And that person is not their database. They've not been arrested and had to give up their DNA before. But then they run it on Family Tree DNA, and it comes back. It doesn't match to that person, but it matches to you. And then they identify based on its male DNA. They identify it as your brother. Now, your brother's not a killer. Your brother didn't actually kill anybody, but did happen to drive down that highway and flick a cigarette butt out their window. There wasn't a dead person there at the time. There was just a future crime scene. So they just flick a cigarette butt out the window. They shouldn't be doing that, in these days of wildfires and so forth. But at the end of the day, and so now that cigarette butt is found next to a homicide. And how do you show that you didn't kill the person? It's going to be real hard because, in fact, it can show that you are right there. It shows that you are right in the place. So, you say you have an alibi, but your alibi, in fact, takes you right past the location. So, yeah. I've had clients who had fingerprints found at scenes and were completely innocent. I've had clients who had DNA found at scenes and were completely innocent. I can list dozens and dozens of cases where I've had people whose DNA was found at a scene that they had nothing to do with. And, there's all sorts of situations. So, and flicking a cigarette butt out the window is breaking the law. I mean, it's very different than a murder. And you could go off the age of the cigarette butt versus the freshness of the body. If you threw your cigarette butt out an hour before the body, I can tell you there is no forensic test on the planet that will separate those out. Sorry. It's just not, this is not the case. I've had people who were arrested on the basis of there's a break and enter at a building and they find a pop can that's left behind in the house that was broken into of a brand that they never, that the homeowners never consume. And when they DNA test it, it matches to a person. And I had this case, it matched to my client. And they looked at my client's record. They said, you've got break and enters. You're going down for this. And I was able to point out that the prosecution's case had a bit of a problem, which was that my client was in jail at the time that the break and enter happened. Like the entire time that it happened. So they really thought my client was there. And if he had been anywhere other than in jail, he would have done time for that break and enter. Now you might be saying, how does that can end up there? Well, I don't know. But my theory on that, and this is like my best guess, is that the guy who broke into the place also was picking up cans, like just collecting cans by the roadside and so forth, and then just went in, broke into the place, and probably left the can behind because he was carrying loot instead of that can. Because the can's worth 5 cents at that point, and maybe the TV he was carrying out or whatever else. Yeah. And somebody says, or he broke in before and left it. No. It was literally they had the break and enter down to one specific day because it wasn't broken into when the family left for work, and it was broken into when they came home from work. So it happened sometime in that work day period. And my client was in jail that entire time. So there is no way that he left the can behind himself. Literally no way. It was just not a possible scenario. Unless he broke out of jail, had a pop, and then broke into a place and left the pop there. Like, that would be weird. So, yeah. They're also noting that, opting in is the default for some of these companies, and that it's not obvious how to opt out. So this is a problem. I don't want my DNA in one of these databases because it is a real problem, in the sense of you leave DNA everywhere you go, like everywhere you go. And you don't know what's going to happen at a particular place, right? You don't know what's going to. And so if the police have everyone's database or everyone's DNA on database, it connects up. And I see odd luck that the DNA of a known B&E convict happened to be brought to a B&E. It is. But there was literally no way my client did it. Like, no way. He got arrested like 2 days before. So, unless he's got a time machine, in which case, why is he breaking into people's houses with his time machine? There's all sorts of, nasty possibilities on all of this. Another possibility. Let's say your family's got an interesting history. And by interesting history, I mean something like your dad has a second family on the side. like, went off and sleeps with a bunch of other people. So, your dad is a hound dog. So, you're sitting there and you think you've got one brother. And in fact, you've got like 40 half brothers, because he's just, he's always out and about. So, they go and they find a genetic match to you or to whoever. And the first person they arrest is your brother because it's male DNA and they think, hey, it's got to be connected. That guy ends up in custody until he sorts it out and they determine, oh, wait, it's somebody else. Lots of possibility for things to go way wrong. Yeah, and this is a good example, like the Dutch IVF doctor or the guy who was banned from contributing to sperm banks by court order. Yep. There's lots of people, for instance, where mom and dad get into a relationship when they're 16. They give up their first kid for adoption because they're 16. But they stay together and they have several kids later on. And so there's a sibling out there that you don't know about and that is a family secret. So, yeah. All of this is potentially an issue. Another concern that we have is at this stage, so there is technology to forge DNA. And it's described in a couple of papers, but it's not been put to large use. But basically, the way this technology works is that you can take a DNA sample, you can knock out the genetic material, and then you can plug it into something else. So what that means is that it is also possible to fake DNA. We're also starting to see some cases of people doing things where, and so what that lets you do, for instance, is take DNA that you got from a skin or a mouth swab and make it into a blood sample. It's described in research. It's possible. And so if you've got the ability to fake DNA, well, then planting evidence at a crime scene gets real bad. And people are shocked by this. Yes, you can fake DNA. The other thing, and this was an allegation in O.J. Simpson's case. O.J. Simpson's case, the allegation was, one of the allegations was that there was a vial of blood that was given to a racist cop that then was taken on a drive for some mysterious reason and ends up partially full. Now, I don't know what happens there, but the argument was that blood vial used to create a fake, some fake evidence. Possible. So that's concerning as well. So all of this is worrying. I'm also going to note that here in Canada, they have floated proposals to require all of these genetic databases to make their data available to police. So that's a problem. We're also, I suspect, going to see situations of criminals mucking around with DNA in order to, throw things off. So it will not surprise me to see at some point that we will see, people, for instance, you find somebody's vomit at outside of a bar, and you move that to a planned crime scene, and you leave it behind. All of these are possible. So this might solve some crimes, but it might also send some people who you know, who shouldn't be in jail to jail. So, Tam, yes, and I would love to go over the, over the thing there. I've done a rant before on why OJ. OJ probably did it, but he was properly acquitted, if that makes sense. So, yeah. So this is very concerning if they're accessing stuff that they shouldn't be accessing. And there are real issues there. So yeah, we'll have to see. This case has me concerned, but what can you do? All right. There are some other things I wanted to talk about, some of which are silly and fun, and some of which are less fun. What do we want? Do we want a really silly one or a less silly one? Chat, what do you think? Really silly or less silly? Just waiting because there's always a little bit of a delay there. And somebody's asking what I'm drinking. It is a canned margarita. So, all right. So I see people saying silly. Let's pull up a silly one. Oakville Council passes a bylaw banning kite fighting. Of all the things that I did not... Oh, am I really being accused of being an imposter because I'm not having hot sauce? All right. All right, back to kite fighting. So, I never thought that this would be a problem. I never thought that this would be a thing that is a major issue. So, what is kite fighting? So, kite fighting is a sport essentially where you have kites that are up there and people are using lines that trail behind the kites. Now, the problem that they're having is that these lines are actually they're pretty nasty. So they note that the problem involves the fishing kite strings, which are sharp and can be made of metal, wire, piano wire, fishing line, or types of nylon that have been chemically treated or contain glass fragments. So, what do? Well, you fly these kites, and your goal in all of this is to cut the strings of the other kites. So, and then the last kite standing is the winner. Now, why is this a problem? Well, because afterwards, there's all of these kite lines that are around. And these kite lines end up floating down range. And there's a particular property owner who was very upset because they kept having these like dangerous kite lines there. And they noted that like one of these kite strings, which again, they're sharp, they can have broken glass along them, came to rest along a trail at neck height. So that was a concern. So the town proposed a law banning kite fighting, and this is given at, and they're saying that they're going to ban it on both private and public property. So that is, a concern there. But yeah, they're actually banning kite fighting. I did not see that it was going to be a big thing. They also pointed out that apparently some people have died in kite fighting. And I don't know how that happens. because shouldn't the kites be way up in the sky and so forth and, whatever? But I'm like, people have apparently died from kite fighting. And that's weird. Now, the punishment on this one is going to be a $300 ticket with escalating penalties. But, yeah. I guess I can understand why that could be an issue, but that Mario kite looks so innocent. I don't think the kites they use for fighting look anything like these kites. I think the fighting kites are usually sort of a triangular shape with like the multiple things so that you can swoop them around at fast speeds. That's my thinking on that. But I can't say for certain. Can't say for certain on it, but yeah. Now nobody in Oakville has died from kite fighting, but it's there as a possibility. Now I guess let's move on and talk about a sad case, because we had a. I'll go through some super chats here quickly, and then we'll talk about a sadder case. So just 1 second here. So Stuart Tamahana says secret hidden linking databases. Yeah. Concerns. Isn't exploiting a security flaw for any purpose a federal crime? But it's the police. Who's going to charge them? Like, pup snacks, actual snacks, not Ethernet cable. I gotta say, Zora has been a real jerk lately. So Zora was begging for a. I've got some. What do you call them? Cherry tomatoes in the garden, and the cherry tomatoes are fantastic. They're delicious, but Zora was begging for a cherry tomato, and so I was like, "You don't want this." And I let her sniff it. She was like, I definitely want this. So I let her eat the cherry tomato. And she just chewed it a couple of times and then spat it out. But here's the problem. Now, Potter, I was like, Potter, do you also want a cherry tomato? And he sniffed it and went, no, I do not. That does not smell like food. I'm just going to eat my kibble. Thanks. I found Zora ate 2 more cherry tomatoes, but she didn't actually eat them. She just took them out of the garden with her mouth and chewed them a couple of times and then spat them out near the road or near the path. And I'm like, seriously, dog, I was going to eat that and you just chewed on it and then out it goes. Yeah, I was not happy with that. She also does like raspberries. And so my wife and I have a raspberry bush in the backyard. And Zora steals the raspberries. So my wife and I get to eat very few raspberries because Zora has figured out that she loves them and will steal them. And it's like, we're going to have to put up a fence to keep the dog out of our garden. So, yeah. Yeah. My friend Dan lost to depression 5 years today. I'm sorry to hear that, Nicole. That's a tragic end, and to Dan. Witchy Jessica, thank you very much for the membership there. Much appreciated. Here for years, says a close friend did a DNA test with his daughter, found out he's not her father, but his ex-wife is deceased. He now tells everyone not to do the test. Yep. Some things you'd rather not know. Right? Some things you'd just rather not know. Maternal Gramps was a sailor. At his funeral, I found out I had more cousins than expected. Fair. Don't police and prosecutors need a court order to access the DNA held in something like 23andMe? For some of them, they need a court order. For some of them, they just ask nicely. It depends on the database. and their policies. And Braden, I'm that adopted older sibling. Both parents have passed away, but DNA led me to a beloved brother I couldn't have found otherwise. And there are some happy stories from it as well. Braxton Heaps, you mentioned you have dysgraphia. I've never known anyone other than myself that has it. How has it affected your life? How did you overcome it? I have a career in IT, and it was a struggle to get here. It has affected my life because it makes it really difficult to take a lot of tests. So when you're in school and they're like, okay, the test is you're going to write something out with a pen, it is brutal. So I ended up getting permission to use like computers to take a lot of my tests. So yeah, it has messed with me. And you get people who are like, oh, just handwrite stuff. I'm like, yeah. So, all right. And what is it? Against the Tide says, didn't I mention a fence a while ago? Yes. It's just tough to actually set that up. And Joe Lloyd, thank you very much for the £5 super chat there. Much appreciated. Somebody's mentioning that there's apparently a report of a shooting at the West Edmonton Mall. I don't know what that's about. So I hope everyone is fine. There's no reports of injuries so far. All right. Now, I don't normally cover a lot of civil stuff, but today I'm covering some civil stuff, and I'm covering some Canadian civil stuff. And that is the case of Sanders versus Canada's Choice Investments. And I'm covering this one in part because it is of a really nasty scam. And I hope you guys don't fall for it. And I hope you guys, if you've got older relatives, that you watch out for them. Because this one is a story of a kid trying to protect their older relative. Did I give Netflix permission? I did not, and I'm not going to. I'm not going to sue them, but they don't have my permission. So, all right. So Sanders versus Canada Choice Investment. And this is Victoria Sanders by her litigation guardian, Cian Rawkins, as the plaintiff. And they're suing Annette Jane Law Professional Corporation, Canada's Choice Investments, Centrum Smart Mortgages Incorporated, Eco Home Financial, Summit Home Services Group, Crown Crest Capital Management Corporation, Alexander Carter, Silver Fund Mortgage Investment Corporation, and a numbered company. All right, so this is an application for an injunction. And an injunction, basically, this is before the trial, and they want to prevent the other side from doing a thing. They want to ban them from doing a thing. And in this case, what they want to do is they want to ban the other side from enforcing a mortgage. Now, why do they do that? Well, Victoria Sanders is a 78-year-old woman. In July 2021, she lived alone in her semi-detached home on a modest annual income of less than $60,000 per year. She has Alzheimer's disease. Sorry about that. Ms. Sanders alleges that starting May 2021, strangers visited her home and through a series of misrepresentations and pressure tactics, persuaded her to take out a $500,000 one-year loan secured by a first mortgage on her house. The terms of the mortgage required her to prepay $125,000 in interest costs, a $25,000 lender fee, a $3,500 mortgage arrangement fee, a $15,000 fee to the mortgage broker, and $1,700 for the lender's legal fees. The cost of borrowing to Ms. Sanders was 34.2% for a mortgage that she says she does not want or need. So on June 8th, Ms. Sanders, through her litigation guardian, commenced an action against a range of defendants, including two private lenders who hold the mortgage on her home. She asserts that the mortgage is unconscionable and that she was induced to sign the mortgage through fraudulent misrepresentations and that she did not have the capacity to contract. And now, when she's alleging this, this is through her litigation representative. She's got Alzheimer's. She can't manage her affairs at this point. So every time you see she alleges, this is being alleged by somebody who's acting on her behalf. Ms. Sanders seeks to rescind the mortgage and to correct the registry to remove the mortgage from title. She also claims general and punitive damages. The mortgage came due on July 30th, 2022. The lenders intend to enforce the mortgage and sell Ms. Sanders' home. Ms. Sanders brings this motion for an injunction to prevent them from taking any steps to enforce the mortgage until trial. So she is 78 years old. She's got Alzheimer's, and they want to throw her out of her house, is what this comes down to. The court says, I grant the injunction, which is in the interest of justice. I am satisfied that Ms. Sanders has made a strong prima facie case, both that the mortgage is unconscionable and that she was induced to enter into the mortgage through fraudulent misrepresentations. In my view, Ms. Sanders will suffer irreparable harm if the injunction is not granted, and the balance of convenience favors protecting her interests. So, what is going on there? Oh, this is Friday Night Frenzy this week. Paw Nerd Court. The Paw Nerds fight back. Zora v. Runkle. Fred v. EDB. Request for damages and injunctive relief. This will be fun. Oh, I don't know about that. Ooh. All right. So what are they saying happened? Well, basically, she's 78 years old, retired, and lives by herself in a semi-detached home in Toronto. She purchased the home in 1997, and by 2013, she'd paid off the original mortgage. She lives on a fixed income of about $59,000. For many years, she suffered from bipolar mood disorder. Now, I'm just going to say, a semi-detached home in Toronto is worth a lot of money. A lot of money. Toronto's land prices are insane. And so a semi-detached home in Toronto is basically gold. In the statement of claim, Ms. Sanders alleged that she had been the subject of abusive door-to-door sales tactics that pressured her to pay for goods and to obtain loans that she did not need. In some cases, the goods and services were not provided. By June 2021, Ms. Sanders had 2 private mortgages and 4 security interests registered against her home, totaling about $96,000. Ms. Sanders is challenging some of these door-to-door transactions in this action, but they're not the subject of the motion for injunctive relief. Basically, she's saying she was ripped off in lots of transactions, but there's only one that she needs to stop right now. Now, I'm just going to note, there are people out there who are scammy predators. And when they find out that there's an old person out there, old people are targeted for these scams all the time because they're perceived as less able to resist them. It is absolutely tragic. I can also note that I don't open my doors. My front door, I don't open it unless I know who you are and why I'd want to talk to you. This annoys door-to-door salesmen to no end. And at the end of the day, my position on that is fuck them. Because nobody has ever door-to-door sold me anything that I want. And so when somebody comes back and is like, hey, I've got, whatever. It's like, no. We had somebody who was an energy scammer who just tried to, who tried to pull that on me. He got my wife first, and she was like, I don't know what this guy's saying. So I want to, she tagged me in because I've got more experience with scams. And yeah, okay, you just answered why I get 100 calls a day for an old man who used to have my phone number about his house in the next town over. That's exactly it. People looking to rip off old people. It is gross. So, one of those security interests was in favor of Canada's Choice Capital in the amount of $9,199. It was registered on title in March 2nd, 21 for home air ventilation equipment and whole home plumbing valves. Does that sound like a thing you need? Whole home air ventilation equipment and whole home plumbing valves. I'm also going to note, if somebody calls you up and they want to do duct cleaning, don't. The people who call you up for duct cleaning, yeah. I can tell you, I don't open the door. I just shout through the door. I've had police come to my door and are like, hey, we want to talk to you. And I'm like, cool, I'm not opening the door. Like, yeah. So the sole director is Mr. Ayub, not Massad Ayub, different Ayub, who is the sole director of CCI, one of the lenders who now holds the mortgage on her house. On cross-examination, Mr. Ayub refused to answer if he was the sole owner of each corporation and refused to explain the difference between the two companies. That's bad because, yeah. So I get the duct cleaner calls twice a month for the past 3 years. I can tell you that the duct cleaning scam, how that works is they will quote you a price. They will say, okay, it's $50 for duct cleaning. And then they will show up at your house. They'll do the duct cleaning and they'll start in. They'll be like, and either they'll start pressuring you for additional costs, like you have to do this, you have to do that, and get in your face and really browbeat you about it. And before you know it, it's like $1,000. Or at the end of it, they will just come back and say, oh yeah, we did the duct cleaning, it's $1,000. And you're like, but you quoted me $50 on the phone. Oh yeah, that was for one duct. You wanted us to do the whole house, so we did every duct, and it's $1,000 now. And you're like, so every time those duct cleaners call me, I keep track of the addresses of demolished houses in my neighborhood because there's a lot of construction. There's a lot of houses that are getting pushed down to get rebuilt, and so they're empty. And so when the duct cleaners call and they say, hey, I give them details. I'm like, oh yeah, I've got one furnace and 2 bedrooms and, whatever else. And they're like, great, what's your address? And I give them my address, except it's not my address. I give them the address of an empty lot where they have literally knocked down the house. And then they say, okay, we'll come by. And the thing is that they actually check Google Maps to see before they go. And I found that out because I tried to send them to the cops and they did that. They would look it up online and on Google Maps and be like, no, you're trying to send us to the police. But the thing is, on Google Maps doesn't update fast enough to show that a house has been knocked down. So they'll show up, find that this house has been knocked down and that it's an empty lot. And it's like, hey, you want to run scams? F up yours. I will waste your time. So, yeah. When you find a scammer, I figure it's your obligation as a human to waste their time and screw with them. Because, yeah. All right. So, Mr. Ayub is refusing to answer questions on cross-examination. That's a bad thing. Ms. Rockin stated that she received a call from Ms. Sanders' insurance broker around May 31st, 2021. The broker told her that Ms. Sanders had called to ask about obtaining additional insurance due to a large mortgage she was getting on her home. When Ms. Roggins asked her mother about this potential new mortgage, Ms. Sanders stated that she had to get a mortgage due to a court order and that the mortgage would disappear in a year. These explanations did not make sense to Ms. Rockins. Ms. Sanders subsequently told Ms. Rockins that in May and June 2021, some men knocked on her door and began to pressure her to take out a mortgage on her house. So here's how this scam works. They go and they get her to take out a $500,000 mortgage on her house. The term of the mortgage is 1 year, which means a year from when she takes out this mortgage, she has to pay the money back. But she doesn't have the money because the scammers took a ton of the money. So she gets this payment and she's like, yay. And when they say it's going to disappear in a year, it doesn't just go away like magic. it goes away and you owe the money. And if you can't pay the money, they take your house. So that's the scam. And they came and pressured her to take out this mortgage. And yeah. So on June 1st, 2021, without Ms. Rockin's knowledge, Ms. Sanders filled out a mortgage application on CCI letterhead. The application requested a loan of $400,000 with prepaid interest. The form incorrectly stated her annual income was $44,000. On June 2nd, 2022, Ms. Rockin's husband participated in a call with Ms. Sanders, Nancy Collier, a lawyer. I've actually talked to Nancy before, I believe, and a person who identified himself as Omar Khan. According to Ms. Rockin's husband, Mr. Khan stated that there was no plan to get a mortgage and that a mortgage was only one option under discussion with Ms. Sanders to consolidate her other high-interest loans. On July 17th, 2022, Anant Jain, a lawyer, arrived at Ms. Sanders' house. The mortgage broker, the defendant Centum Mortgage Smart Incorporated, arranged for him to represent Ms. Sanders on the mortgage transaction. Guys, we're gonna have some swearing to do shortly. This was their first meeting. Indeed, it appears from his file that he conducted the conflict search on July 17th, 2021 at 10:57 a.m., i.e. just before he comes out there. So the entire meeting lasted about 30 to 35 minutes. Mr. Jain, who testified that he'd acted for one or two elderly clients since his call to the bar in 2014, made no notes during the meeting. This is stupid because as a lawyer, you make notes during every meeting so that if you're ever asked to justify your actions during that meeting, you can do so. Mr. Jain brought with him a stack of pre-printed documents related to the mortgage transaction. He received these documents from CCI or its lawyers on July 17, 2021 at 12:02 p.m., i.e. the same day. He did a conflict search before he ever talked to Ms. Sanders. They sent him the documents that same day, and one of the documents that he brought with him was a 6-page conditional commitment letter on the CCI's letterhead. This document proposed a loan of $500,000 for a 12-month closed term at an interest rate of 25%. It was to be secured by a first charge on Ms. Sanders' home. She would also be required to prepay the interest amounts, along with a $25,000 lender fee, a mortgage arrangement fee of $3,500, and the lender's legal fees of $1,700. Ms. Sanders also signed a letter of direction authorizing payment of a $15,000 broker fee to the defendant, Centum Mortgage Smart Incorporated. Ooh. Ms. Sanders signed a retainer letter with Mr. Jain and an acknowledgement of legal representation confirming that Anant Jain was consulted by me as my personal solicitor. His evidence on an examination on this motion was that Ms. Sanders read and understood the mortgage documents and that he explained the transaction to her. Ms. Sanders later told Ms. Rockins that she did not know who Mr. Jain was or that he was a lawyer until she looked at his business card and that he left at her house after she signed the mortgage documents. Mr. Jain charged Ms. Sanders $3,000 in legal fees for his representation. Now, who does this feel like Mr. Jain is representing here, right? Who does this feel like he's representing? And so the lenders funded the loan on July 30th, 2021. In addition to the interest and fees described above, the mortgage proceeds were also used to discharge $45,428 in prior mortgages and security interests, including $11,862.75 to CCC. The remaining balance of $248,697.15 was paid to Anant Jain Law Professional Corporation. In trust, that amount, less Mr. Jain's fees, was paid out to Ms. Sanders. So she's ending up with a $500,000 mortgage, and she's getting half of that herself. So she ends up owing $500,000. She gets paid $250,000, And everyone else in that room is walking out of there with tens of thousands of dollars. So Ms. Rawkins here learns that Ms. Sanders had signed the mortgage. She takes the necessary steps to invoke the power of attorney for property that she held for her mother and to register a caution on the title, i.e., this mortgage is sus. She puts a big sus flag on that. And I see we're congratulating Rob. I don't know what we're congratulating Rob for. The chat is flying by. All right. So, September 1st, her doctor provides an opinion that Ms. Sanders was suffering from a medical condition that is adversely affecting her judgment with respect to all financial matters, and concludes that Ms. Sanders is unable to participate in the management of her finances at this time. Ooh, new job. Congrats, Rob. I hope that's the job we were talking about before, so congratulations. So she is later diagnosed as being unable to participate, and that is because of Alzheimer's disease. So they find this woman who is like suffering from some major health concerns, and they get her into this really horrible mortgage. So CCI basically says, listen, CCI's claim is, listen, we didn't do any of this stuff ourselves. Centum is not us, but they're able to act as a broker for us, and so they're able to use our letterhead without providing us with advance notice. CCI also says that they say, listen, you didn't take any steps to have her declared legally incapable prior to the mortgage being registered, so you should be on the hook for that. So yeah, this is yeah. So now we run into the question of, given all of this, what is the test for an injunction to restrain a mortgagee? And what do they mean by they want to restrain the mortgagee? They want to prevent CCI from selling this house out from under Mrs. Sanders. And when you think about it, in terms of like who's going to lose the most if this happens, this house is not going anywhere. So if later the court determines that this is a valid mortgage, then they still have an interest in this property. Whereas if the court does not determine that or determines that this is a fraudulent mortgage, they can't get her house back. They could pay her money, but at the age of 78, with Alzheimer's, moving to another property is a big deal. If you move to another, like she's known, if you have memory trouble and are, a familiar space is really important. So, yeah. CCI basically says we should be able to sell this house because we don't think she's got a good enough case. And the court says, we actually disagree. The court says we think she's got a strong prima facie case, and that, quite frankly, she's likely to win. And I'm seeing 3 seriously injured in the West End shooting. All right, we'll have to see what's going on there. Unconscionability is basically saying, now, an unconscionable contract is a hard thing to prove. You can't just say that you got a bad deal. So, for example, let's say I buy something stupid and I spend an incredible amount of money on it. So let's say I buy a monkey picture and I spend $500,000 on it. Well, that's probably not going to be found to be unconscionable because I am an adult, I'm a lawyer, I'm all of these things. There's no pressure. Nobody comes to my house to threaten me. Nobody, anything like that. But it's just like you made a stupid deal. You bought a stupid monkey picture, and that's on you. But if you've got a situation where you've got somebody like a child or a young person, or very much throughout the case law, they always they go down to the elderly person, or the vulnerable young couple. The other example they give here, I'll just read the paragraph here. They say courts, as a result, do not ignore serious flaws in the contracting process that challenge the traditional paradigms of the common law of contract, such as faith in the capacity of the contracting parties to protect their own interests. The elderly person with cognitive impairment who sells assets for a fraction of their value. The ship captain stranded at sea who pays an extortionate price for rescue. The vulnerable couple who signs an improvident mortgage with no understanding of its terms or financial implications. These and similar scenarios bear little resemblance to the operative assumptions on which the classic contract model is constructed. So, as an example of an unconscionable contract, let's say I am lost in the wilderness and I am like dying of thirst. And I stumble out and I've been dying of thirst and, whatever else. And I managed to stumble out to the parking lot of like the base camp of this trail. And nobody's around except for this one guy in a truck. And I go up to this one guy and I'm clearly dying. And I'm like, water. And the guy's like, I'll sell you some water. And he's like, and I'm like, oh, sell? Okay, how much? And he says, $100,000. And I'm dying. So I agreed I'm going to pay him $100,000 for the water. And later, he goes to court and he says, I want this $100,000 he promised me for this bottle of water. The court is going to cite the doctrine of get v fucked and reject that. And I see Rob's got a good point here. The vulnerable who are easily persuaded by big names who have built their career on trust. Yep, that is a possibility as well. Like, say, Sotheby's. So, yeah. In this case, we've clearly got this older person with mental, defects here. So that they're going to find that it's, so unconscionability requires two things in Canada. The first thing is an inequality of bargaining power. And inequality of bargaining power can come from all sorts of things, like I'm dying, and so forth, or I am infirm, or whatever. If you're illiterate, those kinds of things. And an improvident bargain means that the bargain itself is unfair, and it has to be unfair in the direction of the stronger party. So, for example, if I go and, if I pay $100,000 for a bottle of water, that's clearly an improvident bargain, right? You'd never make that deal if you weren't desperate because you were in fear for your safety. But let's say we make a deal that's not an improvident bargain. I pay the guy $1 for that bottle of water. Well, a bottle of water sells for about $1, except that now they're selling for like $3 because of inflation. But like, $1 is not an out of line amount. Or let's say it's improvident the other way. I end up getting, like, the guy sells me an entire truck full of water, including the truck, for $10. It's like, that's an improvident bargain, but they're actually probably going to uphold that contract because the stronger party is the one getting ripped off. So, yeah. So they say there's a strong prima facie case that the mortgage is unconscionable. What does CCI say about this? They say that it's not grossly improvident. So the CCI says that it's not, and Why do they say it's not grossly improvident? Well, they point to Criminal Code Section 347. Criminal Code 347 makes it illegal to charge interest more than 60% per year, i.e., that is the criteria for loan sharking. And then CCI points out that the interest rate on the mortgage is similar to what credit card rates routinely charge. However, nobody puts a house on their credit card. Like, yeah. So the court just kind of looks at this and says, and first they say that the grossly improvident standard that they're trying to use was rejected by the Supreme Court. It's only whether it's improvident, not grossly improvident. And they say second, the argument that it's credit card rates on a mortgage does not indicate that it's not improvident. It actually indicates the opposite, that it's super improvident. I'm just going to note, like, my wife and I have a mortgage, and, it's at like prime plus 1% or something like that. Or prime plus 2, or I'd have to actually check. And even though interest rates have gone way up, that's still way less than what credit cards are charging. Yeah. Second, CCI submits that she had independent legal advice before signing the contract, which means that it cannot be an unconscionable transaction. Now, here, Ms. Sanders has provided evidence that Mr. Jane's evidence may well have been pro forma and ineffective. Ms. Sanders did not choose Mr. Jane freely from among all the lawyers in Ontario. He was provided to her by the mortgage broker defendant, who received a $15,000 fee for arranging the mortgage, i.e., they might be in cahoots. There is no evidence that he helped protect her interests or to negotiate any of the mortgage's more onerous terms. There's no evidence he suggested that she explore other lenders or loan structures. There's no evidence that he cautioned Ms. Sanders about the onerous repayment terms or asked how she proposed to repay this mortgage in 1 year, given her fixed income of $59,000, right? You can do the math. There's no way she's making $500,000 in that year. The evidence suggests, rather, that Mr. Jane presented the mortgage documents prepared by CCI and its counsel as a fait accompli. While Mr. Jane dutifully created a paper trail on which CCI hopes to rely, and while this is issue for a trial, Ms. Sanders has led evidence that causes me to doubt that the services provided by Mr. Jane will ultimately be described as either independent or legal advice. Do you know how damning that is? This is the court base. So judicial snark is a whole art in and of itself, right? Where the court is, and somebody's saying, how is she making $59K a year? I'm guessing that's a pension. What is it? So they're saying, like, judicial snark, judges don't typically come out and say when they want to bash somebody. They just kind of hint it. And here, when the judge says, it leads me to doubt that the services provided by Mr. Jane will ultimately be described as either independent or legal advice, what he's saying is, I think this guy might be a fraudster in cahoots with the others. Yeah. Now, that connects us to, let's just jump over real briefly and look at a completely unrelated case. Law Society Tribunal Division, Law Society of Ontario, and a guy whose name we've never heard of, Annette Jane. Oh, wait, that is sounding familiar. Notice of motion for interlocutory suspension or restriction. So, the Law Society of Ontario brings a motion seeking to suspend or restrict the respondent's license on the basis that there are reasonable grounds for believing that there's a significant risk of harm to members of the public or to the public interest in the administration of justice if the order is not made, and that making the order is likely to reduce the risk. So, the grounds for the motion. The Law Society is investigating the respondent, that's Mr. Jain, the supposed independent legal counsel, for, among other things, participating in or facilitating mortgage fraud and a mortgage financial exploitation scheme involving vulnerable senior citizens. The evidence the Law Society has gathered to date establishes reasonable grounds for believing that permitting the respondent to continue to practice poses a significant risk to the public. The evidence the Law Society has gathered to date establishes reasonable grounds for believing that permitting the respondent to continue to practice poses a significant risk to the public interest in the administration of justice. An order suspending the respondent pending the outcome of any discipline proceeding will reduce the risk to the public and to the public interest in the administration of justice. Basically, we think you're a fraudster, and we want to prevent you from being the lawyer on mortgage frauds. Yeah. During the cross-examination of Mr. Ayub, counsel for Ms. Sanders asked him to provide a list of all CCI mortgages where Mr. Jain acted for the borrower. CCI lenders refused to answer that question on the basis of relevance. Counsel for Ms. Sanders then asked Mr. Ayub to provide all communications between Mr. Ayub or CCI and Mr. Jain that related to her mortgage or otherwise. Counsel or CCI also refused to answer that question on the basis of relevance. It is difficult to see how those refusals were appropriate, i.e., you guys are hiding stuff because we think you're involved, like the judge thinks that they're involved in more scam and that these communications would reveal scam. Given these refusals and considering all of the evidence, Mr. Jain's involvement in this transaction does not undermine Ms. Sanders' strong prima facie case that this transaction was unconscionable, i.e., it emphasizes it. Third, CCI submits that Ms. Sanders cannot demonstrate an overwhelming imbalance in bargaining power caused by her ignorance of business, illiteracy, ignorance of the law on of the bargain, blindness, deafness, illness, senility, or similar disability. Uber makes clear that a finding of unconscionability does not require the imbalance in bargaining power to be overwhelming or rise to the level of rendering a person incapable of entering into a contract. And they say that the imbalance is significant. So, yeah. Basically, they find that there is a strong prima facie case of unconscionability. And, yeah. This is just a shocking, horrifying case. Ms. Sanders paid $171,000 to borrow $500,000 for 12 months. The borrowing costs or annual percentage rate equaled 34.2%. The risks to CCI associated with this loan were minimal. Why does that matter? Well, because typically you're allowed to collect higher interest on higher risk loans. And so, I see Costco selling a collection of hot sauces. I got to go to Costco. I guess tomorrow I'm making a Costco run so I can do a stream on that. All right. The interest and the fees listed above were deducted on day one of the funds advanced to Ms. Sanders. The balance of the money made available to Ms. Sanders was secured by a first mortgage, i.e., it's got first priority. And the reason why this matters is because if you're taking a second mortgage, there's a lot more risk, right? Let's say mortgages have priority in order that they were granted, absent some other shenanigans or the like. Like the first mortgager gets top priority, whereas the second mortgager gets whatever money is left after the first one up to their full claim, right? And the third mortgage, yeah. And somebody's saying, what did she need the mortgage for? They convinced her she needed one for a court order that didn't exist. But yeah, this is not a high risk loan at all. because the property is valued at about $1 million and they have a mortgage of $500,000. Therefore, it's secured for way more than the full value of what they're looking for here. Now I have a hot sauce craving. Oh, and I closed the hot sauce. Good stuff. All right. Ms. Sanders presented evidence that annual percentage rate for a reverse mortgage, which is what this is, and a reverse mortgage is basically you've already paid out your house, but you're taking out another mortgage so that you can get cash out of the house instead of that, would be somewhere between 6.63 and 9%. In contrast, CCI presented no evidence to suggest that 34.2% annual percentage rate was consistent with market rates generally available in July 2021 for a fully secured first mortgage with the features of the loan that it provided to Ms. Sanders. Why do they provide no evidence of that? Because they can't. Because they can't. That's why. Oh, somebody's saying it's out of the Wild West shooting range. Oh, I hope not. That place is going to have some problems. Based on the evidence before me, there's a strong case that the cost of this loan was much higher than the usual market price for such a mortgage. Proof of a manifestly unfair bargain, such as this one, may well support an inference that Ms. Sanders was unable to protect her interests adequately. I.e., how do we know that she got ripped or that she was in a vulnerable situation? Because she got ripped off this badly. In conclusion, I find that Ms. Sanders has presented a strong prima facie case that the mortgage was unconscionable because of an inequality in bargaining power. Fraudulent misrepresentation. So, Ms. Rockin states in her affidavit that she received a call that from the insurance company. She discussed the potential mortgage with Ms. Sanders, who told her that she thought she had to get the mortgage due to a court order, and the mortgage would somehow disappear after a year, which they're saying creates a strong prima facie case for fraudulent misrepresentation. If a judge accepts that evidence at trial, the judge could also infer that Ms. Sanders acted in reliance on that representation to her detriment, i.e., she thought that this mortgage was going to go away, but it wasn't going to go away. Now, CCI submits that there's literally not a scintilla of evidence before the court connecting CCI to the person who procured the mortgage application from the plaintiff. I disagree. First, the mortgage application presented to Ms. Sanders at her doorstep was literally on CCI letterhead and was titled Canada's Choice Investments Incorporated Mortgage Application. Second, there's a Sonnet insurance policy dated June 1 for 2021 for Ms. Sanders' property that named CCI as the mortgagee. The policy period commenced on the day Ms. Sanders signed the mortgage application on CCI letterhead. On cross-examination, Mr. Ayub had no answer for why the insurance policy named CCI as mortgagee on June 1st, 2021, before the mortgage happens, right? This is because the mortgage doesn't happen until later after that. So, yeah. In response to an undertaking to confirm how CCI became listed on this policy and to produce any documentation that addressed this issue, CCI could only offer that the precise circumstance behind this is unknown. However, someone must have called Sonnet to add CCI to this policy. No supporting documents were produced. The fact that CCI's name appeared on a policy with a start date of June 1st, 2021, the very day that someone procured Ms. Sanders' signature on the loan application on CCI's letterhead, is much more of a scintilla of evidence connecting CCI to the door knockers. So, this is also why I do not accept that CCI can characterize itself on this motion as a bona fide purchaser for value without notice. CCI may be able to make out such a defense at trial, but on the record before me, I do not find their submissions persuasive. What is a bona fide purchaser for value without notice? Well, this is an important concept in fraud. So, let's say that somebody steals a car, and it's a really nice car. It's $100,000 whatever. I don't know cars well enough to know what $100,000 car is. But like this car is worth $100,000. Now they take it to me and they sell it to me, and I pay $1,000. Later, it turns out that this car is stolen, and I want to keep the car. I'm going to have a real hard time keeping the car because I need to show, if I want to keep this car, that I'm a bona fide purchaser for value without notice. And what that means is that A, this is a genuine purchase, and B, it's a purchase for the value of the item. Now, it doesn't have to be perfect, but it has to be a reasonable price for the item. And the next thing is without notice, i.e., that I didn't know that there was a scam involved, that I didn't know that this vehicle was stolen. But if on the flip side, I end up like somebody comes to me with this car and says, I want to sell you this car, and I pay $95,000 for a $100,000 car. Okay, now I'm a purchaser for value. And a bona fide purchaser is like, this is a real purchase. There's no indication that we're doing some sham transaction to like hide money around or whatever. And the without notice aspect is nobody has told me that this car is stolen, or there's nothing that really should really get my interest in this. For example, without notice, I might have it on notice that this car is stolen if the ignition is punched out. And I look at this thing and I'm like, hey, what's the ignition? They're like, oh, that's you can fix that for $500. That still should raise my concerns that this might be a stolen car, right? So, but if I am actually a genuine bona fide purchaser for value without notice, the government will protect me, or the courts will protect me as an innocent party in this, basically. So CCI is saying we are an innocent party in this, and the court is going, yeah, get wrecked. You're not an innocent party in this, especially because they were unwilling to hand over any details about the transaction itself. Sketch. Step 2, would Ms. Sanders suffer an irreparable harm? I.e., an irreparable harm, and they'll define it here, harm which either cannot be quantified in monetary terms or which cannot be cured, usually because one party cannot collect damages from the other. So an irreparable harm might be, if I don't get the money now, this person is going to become somebody I can't collect against. They're going to set fire to all the money, and I'll never be able to get it. Or I will suffer a harm that you just can't put a dollar value on. So, for example, of a non-monetary harm, let's say if I don't get an injunction against the other side right now, I will lose my leg. There isn't really an amount of money that puts a leg back on you. But there's lots of things that you can put monetary value on. If somebody sets fire to my house, usually you'll say, well, you can put a monetary value on that. But the question here is, can Ms. Sanders' situation be made right if they just pay the money back later? And they say, I find that Ms. Sanders has demonstrated that she will suffer irreparable harm if the injunction is not granted. The property in dispute has been her home for 25 years. She's 78. She's ill and living with bipolar disorder and a chronic and degenerative condition, Alzheimer's disease. She is suffering from serious cognitive decline, as explained by her psychiatrist and the capacity assessor. Ms. Rawkins, who is a psychiatrist herself, stated that she believes it would be extremely harmful to her mother's health if she loses her home and is required to move. At 78 and vulnerable, Can you imagine that? Um, so I must assess the issue of irreparable harm in the context of the specific facts of this case, which includes my assessment that Ms. Sanders has demonstrated a strong prima facie case that the mortgage is unconscionable. In these circumstances, forcing her from her home would be a profound injury to her dignity, which is not remediable in damages. I find that she has demonstrated the type of special connection to her home that is unique and irreplaceable. If she's forced from her home but ultimately successful at trial, I do not think the harm she will have suffered to her dignity can be quantified in monetary terms. Being thrown out of your house is a big deal, right? And yeah. It also goes on and says, so CCI states that Ms. Sanders will not suffer irreparable harm because she can return the balance of the funds from the original mortgage and obtain a reverse mortgage to pay the loan balance. It seems to me that it lies ill in the mouth of CCI to suggest that Ms. Sanders should be required to obtain a reverse mortgage at much lower interest rate so that it may obtain its profits and protect its capital advanced under a mortgage that may well be found to be unconscionable. Let's translate. It lies ill in the mouth of CCI. It says, sir, how fucking dare you? Where do you get the gall? Oh my God, your audacity disgusts us. That's what the court is saying. That comment you made is reprehensible, and your arguments are disgusting and gross. Go to hell. So, yep. CCI claims that it has sufficient assets to pay damages or restitution to Ms. Sanders if her claim is successful. CCI indicated that it holds assets valued at $3,400,000. It is not clear what type of assets make up this pool. It does not appear that CCI owns real estate, as its registered head office is a mailbox in a UPS store. Moreover, CCI declared irrelevant and refused to answer the following questions during the cross-examination of Mr. Ayub. A, to provide the list of mortgages owned by CCI, including the amount of the loans and the age of the lenders. B, to provide the amount of cash CCI has in the bank. C, to provide a copy of any statements of claim for any lawsuits against CCI, Anas Ayub, or CCC that is not already on the record. D, to provide a list of when the mortgages owned by CCI come due. E, to provide a list of all legal disputes that CCI is involved in regarding enforcement of its mortgages, including a copy of the pleadings. F, to answer whether Anas Ayub is the sole owner of both CCI and CCC. And G, to provide financial statements and tax returns for CCI and CCC. I doubt that many of these refusals were appropriate. Certainly, by choosing not to provide this information, CCI has prevented Ms. Sanders from testing its assertion that it has sufficient assets to pay any damages award made at the end of this case. Absent such documents, I do not give much weight to CCI's assertion of financial health, i.e. they're saying, we've got $3 million. And the other side says, can we see the $3 million? And they say, no, that's irrelevant. Well, you just said it was relevant to saying that you could pay the damages. But you also say it's irrelevant. So the court is going, is the $3.5 million in the room with us right now? And yes, this was in a deposition. So yeah, they can just sort of not answer the questions, but it can be held against them. The other thing here is that the court already is pretty clearly suspecting fraudsters, right? When you have the word of somebody that the court is considering to be involved in a fraud, and all they say is, trust us, we've got $3.5 million, we can pay these damages. No, there is no trust. There is no trust. And this is the other, this is just toxic. I'm also mindful of the fact that Ms. Sanders was able to identify at least 8 legal proceedings that are currently underway challenging the validity of CCI mortgages. These lawsuits increase the risk that CCI may not be able to pay any damages award that may be made against it. Because of their refusal to answer seemingly relevant questions, the information necessary to answer that question is not before the court. I.e., you weasels, you such weasels, and also everyone is suing this company. Everyone is suing them. Yeah. Balance of convenience favors Ms. Sanders. I can summarize this real shortly, which is basically if CCI doesn't get this, they might be out some money. Except they probably won't, because if it's ultimately found to be a valid mortgage, then they still have a claim on this house, which is real property, and they could act on it later. However, if she doesn't get the injunction, she gets thrown out of her house on the street and may never see the money that she is arguing was taken from her by fraud. How does the balance of convenience go? It is totally in favor of literally innocent little old lady. Innocent little old lady's always going to win. Oh, and interests of justice. Yeah. First, CCI, and I want to just note, CCI has some balls on this. CCI submits Ms. Rawkins is the author of her mother's misfortune, as she had notice of the impending loan transaction and took no steps to prevent it from happening. I do not accept this submission. First, it conflates Ms. Rawkins with her mother. They are two separate people. At the time of the transaction, Ms. Rawkins had no legal authority to prevent her mother from signing the mortgage documents. Second, to suggest that Ms. Rawkins is the author of her mother's misfortune is a submission that is completely at odds with the factual record before this court. There's evidence before me to suggest that several people are responsible for the misfortune that befell Ms. Sanders, but Ms. Rawkins is not one of them. You scammy ass mother. You are the author of her mother's misfortune because you involved in this scam is what the court is saying here. You don't get to blame her for not stopping you from ripping her off. Second, CCI submits that Ms. Rawkins did not move promptly or with alacrity, which means speed, to set aside the loan transaction once she learned of it. I do not accept this submission. Once Ms. Rawkins learned of the transaction, she took several steps, including obtaining medical assessments and a capacity assessment of Ms. Sanders, which led to Ms. Rawkins exercising her power of attorney for property. Ms. Rawkins then began to explore an extremely complicated set of financial arrangements into which Ms. Sanders entered even before the mortgage issue in this proceeding. I find that Ms. Rawkins moved promptly. Counsel for Ms. Sanders wrote to Mr. Jane on October 6, 2021, wrote to Mr. Jane to obtain his file and to investigate what happened. On June 8, 2022, Ms. Rawkins, as litigation guardian, issued the statement of claim in this proceeding. The complexity of this claim is evident from the number of defendants, the range of causes of action, and the pleaded relationship among the defendants. I do not see that CCI suffered any meaningful prejudice from the speed with which Ms. Rawkins moved. Ms. Rawkins commenced the claim before the mortgage came due. CCI had received its interest payments, lender's fees, and other profits on the day the loan was advanced. Now, we're going to note here, conclusion and costs. I grant an interlocutory injunction restraining CCI Investments and 1221, the numbered company, and anyone else having notice of this order from taking any steps to enforce the mortgage held by CCI and the numbered company against Ms. Sanders' home, including a power of sale, including the final disposition of this proceeding, or until further order of this court. If the parties are not able to resolve costs of this motion, Ms. Sanders may email her cost submissions of no more than 3 double-spaced pages to my judicial assistant on or before January 16, 2023. CCI may deliver its responding submission of no more than 3 double-spaced pages on or before January 23, 2023. No reply submissions are to be delivered without leave. I.e., Yeah. CCI has to pay some costs. And the question is, how much costs? And the court is ultimately saying, you know what? The costs on this one, you guys can work it out for yourselves. But if you can't, I will weigh in. I just want the court to note, or I just want to note here that do you feel like the court is on the side of CCI or any of those folks? I don't feel like it. I feel like the court is gonna try to hammer them. I feel like the court is not on the side of CCI at all. So now it could turn out that CCI is is sort of the innocent victim of a scam there. But yeah. So yeah. All right. That is kind of what we're looking at there. So I don't know. Do we want to do another one before? I don't know if I've got something good in the yeah, I think it's good that we've got the that it's wrapped up there, but yeah. I guess the other one, we will look at one more just before we wrap. It's a quick one. It's a fast one. And then we'll do super chats and wrap up. So, yes. All right. That one is this. Blackfalds officer, or RCMP officer, charged with theft. So in May of 2022, RCMP members were made aware of allegations that an officer was in possession of seized exhibits taken from the Blackfalds detachment. What does that mean? It means stealing stuff out of the exhibit locker. They got a search warrant and they executed this at the officer's home. And so Constable Brandon Smith has been charged with theft under 5,000 times 2, possession of property obtained by crime under 5,000 times 2. So we don't know what was stolen at this point, but he's been arrested. Now, for the still a cop versus not a cop, he has been suspended with pay pending court and additional internal investigative processes. So he's still getting paid. I'm gonna try to pull the endorsements on this one. Because I want to find out what exactly he stole. Times 2 means that there's probably 2 items. So I want to try to find what those things are and so forth. So I'm going to do a swoop. I'm going to read the last super chats here and so forth. And then we will, then we will wrap up. So doggos. I love those doggos. And yeah, so he went shopping in the evidence locker. Yep, that's exactly it. All right. Just seeing Law and Lumber. Rob, thank you very much for 20 gifted memberships. Much appreciated. They found the items at his place and they're still paying him to be suspended. What the? Yep, that is exactly it. What are the chances the 2 exhibits are 2 little bags of white powder? Low. The reason why I say low is because they were able to identify them as the items. So unless they were like still in exhibit bags, that would be tough. But I want to find out. I'm gonna see if they're actually listed in the information. Informations in Canada are way less detailed than in the US. Emma Z, silly in between cases or in between sad cases, palate cleansing changes from time to time. Good for Monday blues. Appreciate you. Your personal insights feel better. Thank you so much. Tony P, deposit for ringside seats. I think that was for the Zora battle. This isn't for you. This is for Zora to help with her legal fees. I hear her lawyer's been working overtime lately. I will make sure Zora gets it, and then she will probably eat it. Waves high, Runkles, Bobunkles, Banana Fana Fofunkles, Fee Fi, Momunkles, Runkles, Laheim. Thank you very much, Yeska. That's hilarious. M169, my strategy on phone calls is I give the caller 2 seconds to respond. If I don't hear anything, I hang up. That does defeat a lot of scam calls. So, yeah. Jen, thank you very much for the YouTube membership. Much appreciated. Ines, hey, Runkle, great content as always. Thank you very much. Cindy Elise, thank you very much for the membership. Much appreciated. Ray E, thank you very much for the $1 there. And Ray E, I've been curious for a while. Does balance of convenience equal balance of equities? Not exactly. Those are sort of separate considerations here. Balance of convenience is really what it says on the tin. Who's going to, whereas balance of equities basically says who is wronged. So you can be the less wronged party. And so the balance of equities might be in your favor. The balance of convenience could be in somebody else's favor, if that makes sense. And I see an update on the West Edmund thing. Serious but not life-threatening injuries, preliminary investigation, targeted event, and all known to each other. All right, that sounds like gangland stuff. So is what it is. All right, it is now late in the evening. We've been going for more than 4 hours. My throat is beginning to kill me, so I'm going to go have some lozenges and some hot sauce. And yeah, we will go from there. So I'm going to play the outro here and see you guys next time.